However, my lord, due to absence of coordinate bench, as the request was bail application was granted by the coordinate bench. So, my lord, tomorrow the coordinate bench is available. Your lordship asked me, told me that whether bench is available or not. Tomorrow that bench is available. So, matter will listed tomorrow, my lord.
Today bench is not available.
Today not available, tomorrow available.
Which item?
Not item.
Oh.
Is a
Then can it be listed? Oh, 029. Okay, then tomorrow.
obliged. May please have. Wait for listing in petition next week or any date. 25th or 6th.
This bench we do. You want to fix fifth or sixth?
Publish. May please, your lordship, regarding item 20 and 34, lordship. 20 may come up on lordship, we will file an additional affidavit, lordship, regarding the ground of marriage. Can it be on Thursday?
20 and
20, lordship, can it be on Thursday or Friday, any day? We'll just file the affidavit, lordship.
Thursday is the district full time. First, no. First, not possible. First, the original matter is there. In fact. Next week, since
5, 6, 7, 8.
5, 6, 7, 8, 9. We have fixed some matters on 5th and 6th also.
Yeah. 7 is also 8.
Maybe 8. 20, you know.
34 lordship should be possible for the day.
34 case there is available.
8, 5. No?
Next week.
22. And which one CD is available? 30? 34. 34 CD is available. You want an adjournment here. Till when you can retain the case diary?
Next week then you can retain, but otherwise we have to send back the CD.
Similar date on 8 then? List on 8. 8/5. We retain the CD till next date of listing.
One more prayer is there, lordship,
Yes.
regarding listing of a IA lordship criminal in a read appeal lordship, regarding condemnation lordship. It was last listed on 21/2/2000 lordship, 25, but it was left over lordship. Since then, it's not even listed lordship. It's for condemnation lordship, single bench lordship, that read appeal, a criminal lordship.
Maybe by Friday. Friday.
You can go to another bench lordship.
Okay,
no
maybe
problem.
Friday.
Friday. Much obliged. Much
May
obliged.
please, Lord. But I would like to mention one anticipatory bail application to be listed on Wednesday, lordship. Father-in-law in 498A case, lordship. He's a senior citizen, lordship. No.
Wednesday.
Motion matter, lordship.
No, motion is there. Wednesday we have fixed some matters, in fact,
Lordship.
for hearing. It will take some time. So, and again, tomorrow may not be possible. Wednesday, Parivan.
Motion matter, lordship, yes.
Yes. 2 matters are there. 2 matters. Maybe
Lordship,
second.
father-in-law is also involved in this case, so if possible, lordship.
These are the matters ground very similar matters were fixed on this date.
These days.
75 and 2, there are already 6 members.
And here our matter will be a bit different. I think it is a 498A matter. 2nd of October at best. Yeah, at best on 2nd. 2nd of May. Friday.
Obliged.
May it please, your lordship. Lordship, with regard to item number 25, your lordship, senior counsel Mr. K.N. Chaudhary is not available today, your lordship.
25.
5, lordship. My opinion, the matter may come up on 7th, your lordship.
Yes, 25. What is the position? CD? CD not received. You want it fixed on 7th?
7th. So this is an interim order, lordship.
Interim is day. 7th corridor, fix on 7th. We are deciding that grounded adjournment corridor, Mr. K.N. Chaudhary, the learned senior advocate is not available. In that case, you have not received the CD.
If CD is available, we have to retain the CD.
Is it available? No. No, then we pass the order for calling of the case dead. That's why I'm just asking. It has to be come from which district? Morigaon. Okay, then CD not available. Interim be extended till next date of listing. Issue reminder. List on 7th. You're saying 7th?
District is Lakhimpur.
Lakhimpur.
Lakhimpur. 7 lots.
7th. Okay.
Also the interim
Not available. So we are listing it on 7 and extending the interim till 7th.
lordship.
Extend for the interim.
May I please understand? I prefer listing of an interlocutory application for bail my lord, in criminal appeal. Last listed on 5/2/2025. My lord, punishment is 5 years, already 2 years gone, lordship. So I prefer on 6 lordship if possible for orders.
6th.
LCR received lordship.
Okay, then 6th.
Highly honest.
May I please, your lordship? The effective mention item number 36, lordship. CD is not there, lordship. 36. It will be adjourned, lordship.
36 CD available. You are on interim.
Lordship.
CD not available. Issue reminder. Interim be extended till next date of listing. List accordingly. When yes, we extending their interim.
16.
1/6/16.
Must have listed. Interim item may be done.
Yes, we extending.
May I please, your lordship? I am trying for listing for withdrawal of a criminal revision petition. On tomorrow.
Lordship, I beg to mention for listing a criminal appeal. On Lordship 8.
On 8.
On
Wait, please, Lord. So I am praying for listing of an AD petition, Lordship. It was lastly listed on 9/4. On that day, Honorable Justice Malasinandi did not sit, Lordship. Therefore, Lordship, matter was Lordship deferred. Since then, the matter has not been listed. Day after tomorrow, could it be listed, Lordship? For bail.
Day after tomorrow, we have listed some matters, in fact. After tomorrow may not be possible. At best, maybe on 2nd of May.
Second, Lordship.
Yes. Because first we have some matters and 30th, we have some matters.
5th.
5th, okay, then 5th, Monday.
Lordship, this criminal petition may be posted on 5th, my lord, for admission, my lord.
Hmm?
Earlier on 19/2/2035, it was left over.
5th, I don't know, did we on 7th?
Miles. Problem.
May I please, Lordship? Beg to mention for item number 40, Lordship.
1/4/40.
40, Lordship. Perhaps
Yes.
CD is not available.
40, whether 40.
Also, CD not available.
Are you on interim there?
Interim order is there, Lordship. Interim may be done.
CD not available, issue reminder, interim be extended till next date of listing. It can be 19/5.
I
19.
have another for listing a criminal revision petition, Lordship. It was left over on 24th, Lordship.
Maybe on 8 of May.
Can you on 6, Lordship?
6 may not be, 5, 6, many matters are there. Similar kind of matters we have already fixed.
Wait, please, lordship. I beg to mention item number 43, lordship. Taken on witness day, lordship. It is available, lordship.
CD is available.
Are you on interim there?
No.
No.
Wednesday-
Wednesday may not be possible. We have some
Thursday,
matters in there.
Thursday.
Thursday is first.
First.
30th and 1st is not possible. Some matters are there. In
The
fact,
second
first one.
Second. Right, your lordship. It is
Second
available.
or he matters will be so all the matters on second is enough. Second, 5th and 6th. Yes, yes. Seven can be. Okay, then 7. 7th
It
of
is
May.
available, lordship. Friday, lordship.
Oh, your matter CD is available now.
Second of
Friday is
second.
2nd. Okay, then.
Made, please.
7/5 করে দিব 43 to CDB retained till next date of listing. Yes.
I am praying for criminal petition for motion.
Huh?
I am praying listing.
Praying for listing, criminal petition
Criminal
will be listed on 8 of May. 13th. Okay, it will be on 13th because lots of matters are there on 13th. 1/3. It's a motion matter, criminal petition. It's okay, it's not urgent, so urgent. On 13th, 1/3.
May I please also? Lordship, I beg to mention for listing a criminal revision petition matter on 13th of May, Tuesday.
13th of May.
Much okay.
May I please, your lordship? Lordship, I beg to mention a bail application for tomorrow. In Honorable Justice P.J. Sogia's court. Same matter arising out of the same police case is pending, is fixed for tomorrow. Therefore, my matter may come up.
Pending before?
This Honorable Court, P.J. Sogia's court in court number 11.
Okay, then tomorrow. Same matters, other matters are there.
Yes, lordship.
May I please, your lordship? I beg to mention a bail application for listing This matter is listing fixed for today, but it is not listed.
Not listed.
LCR already received. Finally listed tomorrow,
What was the number?
977.
977. It was listed.
Listed.
The or date was fixed.
It was fixed as I have mentioned in the court number 3, but today for today, but it is not.
May not be possible. Most probably that's why it was not listed. I don't know. Tomorrow, and Wednesday and Thursday, it's not possible.
Day after tomorrow. Madam.
That's what I'm saying. Day after tomorrow, lots of matters are there. In fact, some matters for hearing are there. It may reach also. Ketia paribo. At best on 8. 8 of May. Yes, we're listing. It's a AB, isn't it?
BA.
BA. Okay, 8.
I'll bet to mention listing criminal revision, madam.
On 13th, 1-3.
I bet to mention item number 41 for adjournment.
41 for?
41.
Yes, 4-1. What do you want?
Adjournment process.
Are you on interim?
No, no.
You are not in interim. On the request made by so and so, the case is adjourned. CD received, written the case diary until next date of listing. List accordingly, yes, but to Sami, when can it be listed?
9th.
9th of May. 9th of May. We're listing it on 9th of May. 9-5, huh?
May I please? We are praying for listing only admission matter, criminal petition matter. It was posted after BVK. So can it be on 13 or 1 of May? 13 or
13 on 130, 1-3.
My lord, this bail application is pending since 2024. And the prime accused was granted bail on 24/4/2025, my lord. So this will my tomorrow day after tomorrow.
Now see, your grounds of various matters are deferred. That you know, I think. So it may not be serve your purpose.
So even my lord, there are other grounds is there also.
No, whatever. Mainly if his sole ground is there, then I can also. What is the period of incarceration?
Period of incarceration, my lord, almost 9 months.
Though they may not be that may not be a good ground. That's what I'm saying. So let it be deferred until 5th and 6th. Many matters are there.
My lord, I was picked up, my lord, since after March, after 3 to 4 months from the date of occurrence.
Whatever, there may be
my name was not in
I
the
won't say
FIR.
that there is not reason, but ground of various we are deferring. That's what I'm saying. So if that is there, then 6th can be given. 5th and 6th, we are listing other matters also. Your matter will be heard on 5th, 6th.
25 we have received that case is abnormal. So retain that case diary all for
Item number 25. 25 to the 2 asile. CD received the cop. Retain the case diary till next date of listing. Item number 25.
Release item 1.
My lord, in this case, I was arrested on 7/10/2023.
7/10.
10/2023. That is my lord, 1 year, 6 months, 21 days. And by last order, lordship was pleased to call for the records because lordship has granted bail to one of the co-accused persons, and another co-accused was granted by bail by a coordinate bench, my lord. So records were there, absolute records were there. So lordship has taken the records of that cases, my lord. So my lord, I was behind the bar for 569 days in this case, my lord. And along with 2 other persons, my lord, I was arrested in from a vehicle where my lord, contraband weighing commercial quantity was recovered. Then my lord, charge sheet was laid in this case on 31/12/2023, citing 12 witnesses, my lord, to prove the case of the prosecution. And my lord, till date, although my lord, charge sheet was laid on 31/12/2023, till date, my lord, charges have not been framed.
Why?
Oh, my lord, that is, we also don't know, my lord. Only 3 accused persons were there. They are in custody, my lord. Charges were not framed till date, my lord. And lordship order granting bail to one of the co-accused persons has clearly reflected that the charges are yet to be framed, and the date is fixed on 5/5/2025. So on 2 counts, my lord was pleased to grant the co-accused bail. One, my lord, prolonged incarceration, and another is ground of arrest.
And the coordinate bench only will consider the prolonged incarceration part. That order I have my lord is there.
I paid 25 for copies, Lordship. It's for copies on 5/5/25. Charges are 8 to 20.
It is for copies only, my lord, as per my learned statement. And my lord, in paragraph 11, if lordship peruses, the coordinate bench only considered the prolonged incarceration part and was pleased to release another co-accused person. And lordship's order I have the next.
Now see, this order is incarceration coupled with that the grounds of arrest.
yes, madam.
That's what I'm
Lordship has
repeatedly saying. Actually, give some time.
Definitely.
We are not fixing the cases. Because now your case, if I pass the order, then similar situation will be there. So that's why we are just lingering it. There are some situations maybe there that your petitioner may not be caught red-handed. Your petitioner may be subsequently arrested on the basis of the statement of the
Confession
co-accused also that these are there.
Yes.
And as you have submitted that charge sheet has already filed on 31/12/2023, but
Yes.
till that charge could not be framed.
Now, my lunch finance said that it is still for
It's
copies.
still for copy. That's
Copies.
what I mean. Charge is not yet framed.
Yes.
So that may be one of the reasons. But we are deferring the matters. That's fine. So
This matter, my lord.
yes, this
Yeah.
matter. In that case, 5th and 6th, as we have know, I think
Yes, lord.
lots of matters are there on 5th and 6th, maybe on 7th.
Seventh.
7th. 7th. In the meantime, we can call for this thing. It will reach from where it has to be.
Madam, it is pending before the learned court of special judge Sribhumi, my lord.
Sribhumi will reach.
Karimganj, my lord.
Yes. Yes, does. Can it be?
It can be, my lord.
Scan copy is already there. We
Yes.
have record list.
It is up to date, my lord.
Oh, then it's okay. Then it's okay. Then it's okay.
Deeply okay. On 7th, my lord.
7th.
Yeah.
Wait, please, your lordship.
Yes.
Lordship, the brief facts of the case is that, your lordship, the petitioner and the informant were in a relationship, your lordship, since long time. And the informant's parents, your lordship, were not consenting to their relationship and fixed her marriage to another person, your lordship. And following this, the petitioner has informed to that another person regarding their ordeal, which has been going on, that regarding the circumstances, their marriage has not been accepted and all that. And he has informed that to that person. And following that, that very person has cancelled the marriage, and subsequently an FIR has been filed, your lordship. The FIR is at, your lordship, page 11, your lordship.
Who filed it? With whom the marriage was cancelled?
No, your lordship. The FIR was filed against the petitioner, your lordship. It is at page
She
11,
filed.
your lordship.
The victim filed the case. I mean, the girl filed the case.
Yes. The informant has filed the case.
And with you, there was a love affair.
Yes. They were in a long relationship, your lordship. The FIR is at page 11, your lordship. The type copy. Should I read, your lordship?
No, we are here.
Yeah.
It's here. Long relationship was okay, but the question is that when her marriage they have submitted, marriage was fixed, he was threatening her as per the FIR that to establish relationship with me by showing some intimate photos and videos. So that is the case. Let us
IT
call for
Act is
this.
there, Lord.
His IT Act is also there. We are
He has on 25/2, your lordship, and right now he's behind the bar since 61 days. Today it will be 62 days, your lordship.
and these offenses of
The offense date is, your lordship. The FIR is filed at 19/2.
no. Offense is of 60 days or 90 days category.
60 days, your lordship.
All are 60 days.
Yeah.
Just see, BNS to do.
Lordship, out of all these sections, just two are non-bailable.
Which are those?
Your Lordship, 308, section 308,
308.
2 and 316, 2, Your Lordship.
Social losses. Into 7 years, 308 punishment, 7 years caution.
Another one is 316.
316.
It seems that all cases are of 60 days of insight. So
Yes.
your petitioner is behind the bar since 62 days.
61 days, Your Lordship. Today it will be 62 days.
Your Mr.
JK Roy, Your Lordship.
Hard Mr. J.K. Roy, the learned counsel. J.K. Roy, the learned J.K. Roy, the learned counsel for the petition. And also heard Mr. M.S. and does the learned additional PP appearing on behalf of state respondent. This is an application and section so and so in connection with service. It is submitted by Mr. Roy that the present accused petitioner and the victim had a long love relationship, but subsequently when her marriage was fixed with another person, she lost the affair with some false and concocted allegation. He further submitted that the accused is behind the bar since last 25 to
2025.
25 to 2025, and today is the 61 days in his custody, but the investigating officer failed to furnish the charge sheet, and hence, considering this length of detention, he may be enlarged on bail. However, the petitioner is ready and willing to cooperate the IO in further investigation of this case. Next, MS and thus still an additional PP submitted this regard that CD will reveal the actual fact of the case. However, she submitted that the IO could not file the charges till date in spite of lapse of the statutory period. Next, considering this submission made by learned counsel for both sides and without going detail into the merit of the case, the petitioner is, I find it a fit case to allow the petitioner to go on bail considering the length of detention already undergone by him. Accordingly, I provided with the DD1. It is case of Morigaon CGM.
Yes.
CGM Morigaon. To the satisfaction of the CGM Morigaon. Okay, we are granted with bail. There will be some conditions abide by all the conditions.
Item 3.
Yes, please.
Happy July. 483 application. A lordship will find that we were taken into custody on 13 to 24. Today is 439 days. Case has been charge sheeted on 2/8/24. Charge 28/3/24. Charge was framed, my lord, in the meantime, but till today no witness was examined, my lord. And
charge framed on which? When?
Charge framed on 2/8, my lord. 24. Thereafter, the witnesses were summoned but did not turn up. And my lord, for 47, 48, and 50 of the BNS has not been complied with. That's why I pray that the scan copy be called for, your lordship will get this.
Call for the scan copy of the LCR along with the case diary. List the matter when it can be listed.
This from Silchar, Kachar, madam.
On 16th of May, lordship.
16th of May is long. Kindly consider it. 439 days behind the bar.
9th.
9th.
9th. Right. Okay, by listing it on 9th.
Item 4.
May I please, your lordship. My lord, the petitioner was arrested on 13/3/2025. Today is 47 days. And my lord, FIR is page 13. All the FIR is against on co-accused my lord. My lord, the allegation in the FIR that 576 gram morphine was recovered from the co-accused man. And the co-accused man stated his name, the present petitioner, that he purchased from him. In fact, my lord, present petitioner is saying that I am not aware and no connection with that arrested accused person. Other my lord, not mentioned, and his house also searched, my lord, nothing has recovered. And my lord, here 47, 48 also not complying of the assessment.
Lordship CD on eight.
The short date may be given, my lord, 47 days.
8 of May, Lordship.
8 of May. CD we call for 8 of May.
Obliged.
Item 5.
Your lordship. Here in this case, FIR, your lordship will find page 14. Your lordship, allegation is that some contraventions were recovered from the possession of the arrested accused persons. And the FIR name accused person, your lordship will find page 19. These two persons, they were apprehended along with the contraband. And the present petitioner, lordship, he was subsequently arrested on 21/9/2024, lordship. Whereas FIR was lodged on 11/7/2024. And the co-accused was granted bail by this honorable court, lordship. That I'm for one copy I'm handing over to your lordship. And that arrest memo, your lordship, will find page 37. The person from whom recovered, he is on bail. Page 37. Notice and response 47. And that is arrest. And in fact, my case is squarely covered by Bihan Kumar and the other judgments, lordship. And the judgment which is reserved by the Honorable Apex Court, that relates to if a person is caught red-handed, then what will happen? Only on that aspect. And even that judgment is reserved by Honorable Justice B.R. Gagavai. And that judgment is, or the probable procrasta is pronounced by Honorable Justice B.R. Gagavai. Just I'm placing one line from that judgment, lordship. Lordship, may I kindly see one paragraph I'm relying on. Paragraph 45. The other facts, all your lordship has read, just I'm pointing out that. Paragraph 45.
Yes.
We are of the firm opinion that once this court has interpreted the provisions of the statute in context to the constitutional scheme and has laid down that the grounds of arrest have to be conveyed to the accused in writing expeditiously, the said ratio becomes the law of the land, binding on all the courts in the country by virtue of Article 141 of the Constitution of India. So probably that he cannot change, lordship. So it has to be communicated in writing. That observation is already there. And it is already observed that once that interpretation is by Honorable Apex Court, here is no chance of those interpreting those provisions, lordship. And
When it is fixed, this other one, this very not
fixed,
suggested.
lordship. It is only reserved and with only to the issues that whether if it is if the accused is arrested red-handed, what will happen? Whether it has the arrest memo has to be given prior to that or after that. And certainly it has to be given after that, because series of judgments are there which says that the window of 24 hours is there to the investigating officer to serve the copy. It cannot go beyond that. And we cannot ask that before arrest, we have to give even the arrest memo. That is clear, settled law, Lord. We are not disputing that. So only question.
Yes, that is you correctly submitted, and this one is there are some issues on I mean court red-handed issues are there. So no red-handed, but we let it be after 30. Later your hearing will be there on 30.
Lordship, scan is also required.
Pardon?
Can copy it?
He otherwise most probably submitted.
Certificate
He has
copies I have
certified
written
copies
and
is
already
available with him, I
co-accused is
think.
granted.
Otherwise also we can call for the case diary, but he has the certified copy. I
I
think.
have the certificate.
And as you rightly pointed out that there is a law that is a 45, I mean, para 45 is very clear. But that issue is there, so just for time being, where I'm considering
30th.
all the matters on 30 we'll be hearing, and second there is some hearing.
On 2nd or 30th, Lord.
Second,
Because already this much I will submit nothing more, Lord. Because already Supreme Court has elaborated everything. I need not place before this court.
so that judgment is still reserved.
That judgment is only to the context that whether the arrest
Yes,
memo
yes.
is required to be
Yes.
served before arrest or after arrest.
So before arrest or after arrest means the court red-handed.
Yes. So that is the issue. We are not disputing that even if a person is seen committing a crime, police cannot go. That is the settled law, Lord. That is we cannot dispute that. Police cannot go back to police station, type it out or write it down, then serve it. That is probably is not the law. They will be apprehended subsequently within 24 hours. They will be served with the copy of grounds of arrest. That is.
Obviously. That is there. That is there. And your
And
case
in
most
the
probably is
present
not a
case,
court.
even if I exclude that 24 hours, even till today I was not served the grounds of arrest. That is the case. So only that much, Lord.
Okay, then we're fixing on second then.
Lordship.
Somehow we try to manage,
Lordship,
otherwise
Lordship.
the matters have been fixed.
Lordship.
So you may submit on that regard.
Lordship.
Okay. Second of security.
Obliged. And item 10 is also on similar footing, Lordship.
Item 10.
Lordship.
Okay, we are fixing both the matters on second.
Obliged.
Item 6.
May I please, Your Lordship?
Yes.
Lordship, the petitioner was arrested on 29/1/2025, Lordship, and as on today, 89 days, Lordship. They appear
29/1.
29/1/2025, Lordship.
Okay.
The co-accused, namely Lordship Johirul Islam, Lordship, he was arrested and subsequently approached before this honorable court. And that order will find Lordship page 23, Lordship. I have annexed the certified copy of the notices, Lordship, issued under 47 and 48.
Yes, this case is also Assam Cattle Preservation Act is also there.
Lordship.
I mean, initially it was there. So far I can remember, and subsequently most probably some contraband was also recovered. Now same problem will be there. Let us pass an order in that regard regarding the the grounds of arrest, because your case also does not come under the length of detention or whatever.
Lordship.
And that about 89 days most probably commercial quantity, so it will not come under that category also.
Lordship.
So we are fixing your matters on 8.
8.
8 May. Okay.
Case diary may be called for, Lordship.
Yes, CDB call for 8 fixed corridor CDB call. Otherwise, do you have annexed the certified copy of the grounds of arrest and all?
Lordship.
You have already annexed here, or you want
Already
to annex?
annexed. Already annexed, Lordship. Lordship will find page 20, Lordship.
Page 20.
Page 20, 21, Lordship.
Yes, 2021. Okay. But this is not the certified copy. No. Sorry, it is 20 certified copy. 21 is not certified copy.
It's served to the family members, Lordship.
By the time you may obtain it. We are listing it on 7, most probably on 8, na? 8.
8.
So listing it on 8, and by that time you can also approach, and we are also calling for the case diary. CDB call for list on 8 May corridor. In the meantime, the petitioner side is at liberty to file the certified copy of any document, if any, of the document, if any. Because I'm saying that if suppose your ground is there regarding the non-mentioning of ground of arrest, in that case, if you have furnished the certified copy, we can approach you.
7.
There's an
Yes.
application under section 483.
Yes.
Now, my lord, the person has been in the custody for last 10 months. Apart from that, there may be a ground, my lord, arrest and all that. Now, my lord, at this stage, possibly your lordship will like to call for the CD.
You will call for the CD, and by that time, if you have taken the plea of the grounds of arrest,
Yes, that
have
I-
you annexed this the
No, no,
copies?
that-
You have not annexed.
No.
In the meantime, you may obtain the certified copy.
My client.
Certified copy. We are calling for the case diary,
Yes.
and by that time we may. There was some issues raised by the additional PP and some the other advocates also.
Well.
So you are going to hear the matter on 30th and 2nd. Both the
Yes.
matters we have fixed. So let it be after that. We are calling for the case diary also. In the meantime, you can file the certified copy also.
Yes.
Can it be on 8 or 9? 8. 9. Reading him with the ultimate. 6 CD ahi na paban ju.
9 Lord.
9. Okay. Here we are. 9 ko video. CD call for 9 ko video. In the meantime, the petitioner is at liberty to furnish the certified copy of the document, if any. Okay.
Item 8.
Yes. Mr.
Message your lordship. Petitioner was arrested on 15/9/2023, lordship. Today is about 1 year, 7 months, 15 days.
15, 9?
15/9/2023.
Yes.
And in this case, lordship, final complaint submitted. Thereafter, charge frame on 14/10/2024. And in this case, lordship, 4 accused involved, lordship. And thereafter, lordship, dishonorable court, one of coordinate bench has granted bail to the co-accused, lordship. Because of this long incarceration, and from their position, contraventions were not recovered. On the basis of the statement, they were arrested, lordship. That is why they got bail from this honorable court. And lordship, in this case, allegation is that from on the tip of information, the persons, these persons were arrested from a hotel, and from there one bag found, and from the bag contrabands were recovered. That is the allegation, lordship, in this case. We have also taken the plea of non-compliance of section 50 and 47 of BNS, lordship. In this case, lordship, though the copies served to us, but it is not in own language, but without any grounds, lordship. It is in page 88.
So, as per you, the charge is already framed on 1410. How many witnesses it examined till date?
Examined.
2 witnesses out of?
Out of 10.
Out
12.
of 10. 12.
Out 12.
See, the coordinate bench judgment is there most probably, and the grounds of arrest may be one of the factor for the
Yeah,
considering your bail
in this,
application.
in my bail application, I have added this ground, but in earlier petition, only because all these things discussed, lordship, regarding long incarceration. Then lordship, one more is that right under Article 21, because of non-speedy trial, lordship, that is also discussed in this case, in both the cases, lordship. So no, section 50 I have added right now. So lordship, in this case, I think LCR is required, and issue involved, as your lordship is
that is
discussing
the
these things. And in the apex court, in case it speaks worldly hit and run case. In that case, his lordship observed that a lady was hit by a vehicle, lordship, and the lady he brought with the vehicle with a full speed 1.5 kilometer, lordship. Because of that reason, their curiosity is there whether from the person who involved in that case who got red-handed, whether this type of
yes, obviously,
issues or this provisions, they should get the bail or not, that this there, lordship. And one more thing is that in some high court, somebody filed a petition for quashing of this petition, this allegation on the basis of section 50, non-compliance of section 50 and 47.
It is
Because
also
of that
pending.
reason, Lordship, his Lordship is worried about this, whether the provision protected the person's interest, even after that, if he is arrested, caught red-handed, Lordship. In such type of cases, that is why, Lordship, not only in bail, but in quashing matters is also there.
That's it.
Because of that reason, Lordship.
Yes, you're representing?
DRI.
DRI.
Special people.
Acha.
My name should be reflected in
Cause list.
cause list. Right? Yes, Chakraborty.
Sometimes you want your name to be reflected, your name, good name?
Yes, Chakraborty.
BS Chakraborty.
BS.
BS Chakraborty. No? Hardly heard Miss MS SK Nargis, still on a counsel for the petitioner. And also heard MS BS Chakraborty, still on a standing counsel DRI.
Special PP, madam.
Sorry, special PP DRI. Lady case, scan copy of the case record along with the case diary we call for.
It's from Kamrup Metro, Lordship,
Kamrup
it is a 3. Can it be next week, any date? Because Lordship is
Next week, that kind of matters we have already fixed.
along with that, Lordship may fix this matter also. Because it is from
Already many matters are there, so it will be too
seven-
long for if I fix on 13th next week.
7th,
No,
7th or 8th,
13th.
Okay. Yep. If possible, then can it be 8 Lordship? After 7 Lordship, fix so many matters.
Can it be on 8? Okay, then 8. Yeah, registry is also hereby directed to reflect the name of MSBS Chakraborty as special PPDRI. Okay.
Because
Yes, we are calling for the LC.
Item 9.
My lord, here is a case under the NDPS Act. NDPS case number 86/23 pending before the special judge. Now, my lord, he was arrested on 19/7/23. And having regard to the date of arrest, my lord, by this time, he is behind the bars for 1 year, 9 months. And my lord, the charge sheet has already been, my lord, laid down on 31/10/23. My lord, till date, no charges have been framed. And there are 2 grounds, my lord. Apart from section 50, the other one is long incarceration. And in connection with this particular case,
Number of witnesses, how many witnesses?
my lord, in fact, there are
Cited?
in the charge sheet, my lord, there is there, my lord, but here the charge sheet, my lord, is not available. But in connection with the same case, my lord, your lordship was pleased to grant bail to a co-accused by order dated 4/4/25 at page 32, my lord. And both the grounds were taken, my lord, in that case also. And your lordship was pleased to consider it and allow, and was pleased to enlarge.
Actually, what had happened, Mr.
Talukdar.
Talukdar?
Yes.
The question is we were allowing.
My lord.
And we are holding that the long incarceration may not be the ground, but the ground is question is that you were not served with sweat zone.
Yes.
That was the ground, and on that ground we are allowing, and the many matters were being granted bail.
Correct.
But when the issue was raised, I thought that there should be a parity of the order passed by. So that's why this kind of orders we are fixing. I mean, we are going to hear 2 matters on 2 matters, not 7 matters on 2nd, I think 7 or 8 matters, 8 matters, and then on 38 also 1 matter will be heard. There where the other side is also provided some time to provide the if the any written argument is also there and all. So that's why we are actually differing these kind of matters. So in the meantime we call for the
Scan copy.
Scan copy of the LCR. Your matter will be fixed accordingly. Scan copy item number heading 9. Scan copy of the LCR along with the case diary we call for. List accordingly 9 to Kogoin or both assignment fix.
If there are similar matters, then my lord, it will go in one go, my lord. So
On 8, last matters also we have fixed on 8, 5.
apply. Deeply over.
Registry will do the needful query. Oh.
Well.
Item 11.
May I please the lords? Yes. The petitioner was arrested on lordship 6/4/2025. He was forwarded on 7/4/2025 as on today, my lord, 22 days behind the bar. Though, my lord, the case has been registered under the various provisions of the BNS, but it is basically case of section 53(1)(a) of the Assam Excise Act regarding the recovery of the liquor from the possession of the accused, my lord. Now, lordship will kindly come to the FIR at page 13, lord. Look there. So page 14 is the seizure list of the seized article, my lord. My respectful submission will be, lordship, that I am not submitting on merit, my lord. 32 cartons of the liquor has been received, recovered from his possession, my lord. My only submission is that, my lord, they are residing at Bisnath Sariali. This is the bordering area to the Arunachal. Most of the day they went to Arunachal for work, my lord, and subsequently they returned home. And there was so far my instruction is concerned, there was a party, my lord. Party regarding, lordship, we used to say Dhoni Biya of the daughter, my lord. On that was supposed to be solemnized on 13th. And that is why that liquor was bought. That is my submission, my lord. Now everything has been recovered, my lord, already 22 days. So, my lord, that may, considering the length of detention, my lord, further custodial detention may not be necessary, my lord.
Why 61(2) is also there? 61(2). 3184 is also there. 3303. Now you are saying that these are though it was registered on those sections, these are not applicable.
Lordship, because these are regarding criminal conspiracy, theft, and cheating, my lord. Nobody has reported that my lord, the articles have been stolen. Or receiving of the stolen property, my lord, that will not be affected. 51 of the Assam Excise Act, my lord. 53(1) of the Assam Excise Act.
Mark, Arunachal Pradesh liquor were found inside the house of the accused lordship.
In his house, it was
Yes,
from
Lord.
his house.
Not from
Yes,
his house,
Lord.
there is a shop, my lord, and
Were found
between there is a
inside the
space.
house of the aforementioned.
So far, my instruction is
apprehended
concerned, my lord,
accused.
shop is there, and in between the shop and his residence, there is this empty space. Tin shed is there, that was kept there, my lord.
And it is
From there, it was
selling on the same on the black market without any sort of permit of government authority. So lordship city may be called for lordship.
2 days, my lord, only the articles have been recovered now. Whether the custodial detention in this regard will be necessary or not, my lord, that is the question, my lord.
Now see, you have brought a huge number of bottles for
Lordship,
that
admittedly,
ceremony
lordship.
only.
32 cartons,
For
admittedly,
that
lordship,
ceremony,
yes.
if you are spending so much, then okay, we're calling for the case diary when it can be also.
Yes, sir. 9 lordship, 9.
90. Okay. Okay. We list on 96.
Obliged, Lord.
PDB call.
Obliged.
Item 12.
Yeah, please, Your Honor. Your Honor, this is a 483 application. The accused is behind the bar for 77 days, Your Lordship.
Foxo is there, lord.
Foxo is there, Lordship. Notice is resolved.
Foxo is saying. Foxo 6 or what?
8. It's an
8
8.
Fox.
Yes, Lordship. The actual fact of the case is that, Lordship, the informant, the petitioner and the informant have a friendly relation, and they are from the same locality, and they know each other, and there are some monetary transaction between them, Lordship. And when I asked them to return back my money, they took, Lordship, and there was a fight between the parties, between the petitioner and the informant, and that turned into a quarrel, Lordship. And the affair is the outcome of that incident, Lordship. The affair is at page number 14. Lordship.
This is lordship, notice my go lordship.
Notice has to go. Thank you.
Lordship, may I read out the translated copy? It is written in Bengali as well. It is most respectfully stated, my daughter, namely Sanjana Bhor, is about 16 years, 7 months,
The aforesaid accused person has been harassing my daughter in public places for a long time. On 9/2/2025 at around 4:30 p.m. in the afternoon, my daughter went to a shop in front of our house. And during her return from the shop, the accused person blocked her and grabbed her hand and also threatened her. In the meantime, I heard my daughter screaming. Hence, I, along with my family members and other local residents, rushed to the spot and rescued my daughter from the accused and apprehended him until the arrival of Ratabari police station. And on 9/2/2025, police detained him and FIR was lodged on 10/2/2025. My lord, kindly come to the page number 31. Since I am submitting that there are transactions between the petitioner and the informant, it is reflected in the transaction. Page number 41, Lordship. Lordship 29/1/2025 transaction 41. Am I clear, Lordship? Lordship, on 29/1/2025, Bijan Bhor, he is the son of the informant. And the phone number which is mentioned here in the bank statement, it is matching in the FIR also. In the name and address and phone number in the informant. This is 6013233380. The Paytm you pay. The petitioner paid 2,000 rupees. It is reflected, Your Lordship, at page number 41. It is matching, Lordship. So Lordship, this is a complete case of misuse of law, Lordship. Lordship, I was there. I asked them. I helped them when they needed money, and when I asked them, they denied and they put me behind the bar. And I am behind the bar for 77 days, Lordship. I am married. I have two minor children at home. They are starving, my lord, and my presence is necessary, Lordship. And charge is also filed, Lordship. On
filed?
Yes, Lordship. 28 February 2025. That within almost 18 days, the police filed the charge sheet. And Lordship, I have prepared a bail application before the learned court below, and which was rejected on 26/3/2025. I have
Okay, now see, question is that we have to hear the other side because we don't have any alternative. The notice has to go. Otherwise, your submission may be correct or there may be some entries also.
Lordship,
So
there are monetary transactions.
issue notice going to respondent, respond number 2 through jurisdiction police station to the office of the registrar and the public prosecutor. Also call for the scan copy of the LCR along with the case diary. List accordingly, yes, when can be listed. PST will do it in the sorry, he is in 7th. Notice has to go, that's right.
13th floor.
13th. Okay, 1 3.
Sri Bhumi, Lordship.
Sri Bhumi.
Yes.
Okay, we're listing it on 13th. In
Lordship.
the meantime, we'll call for the, if takes it within 2 days
Lordship.
for the respond number 2.
Lordship. Obliged.
45 of the supplementary list.
Yes.
May I apply? Lordship, in this application under section 483, Lordship. In this case, Lordship, he has been arrested earlier also in some similar type of cases in connection with not looking for PS case number case of 1991 25 on 15/3/2025 from his house without following any procedural law. And in that case also Lordship was granted interim bail. Subsequently, after knowing the release of petitioners, on 28/3 another FIR was filed before the Morigam PS case number 90 of 2025 Lordship, and police police has arrested him in connection with arrested him in connection with that case, and had taken few days police custody. Subsequently, he was produced on 5/4/25 before the Morigaon police station, and he was forwarded to judicial custody. Then again, Lordship, after release of this from the Morigaon PS case, when after furnishing bond, while the petitioner along with parents came out in front of the Morigaon police jail, district jail, he was abducted by some unknown person. 15-20% surrounded them and forcefully dragged him in the one vehicle, and they have taken from that Morigaon district jail gate. Subsequently, the parents searched in Morigaon police station, and thereafter they found that he was in Jagirod police station. And at that time, so many people gathered there, and they also took some photograph also regarding that incident. Then he was arrested in connection to one case. They mentioned about that he was arrested in connection to one case filed on same day at 11:20 a.m. Lordship. And in that case, stating about one tweet that he has posted on 2024, Lordship. 29/24, Lordship. On the same allegation, wife of the petitioner also earlier lodged an FIR before the Morigaon Dispur police station, Lordship. And in that case, his honorable court, after hearing, interim bail was granted. And subsequently, that case was charge sheeted, and charge sheet was filed before the learned judicial magistrate here in Guwahati. And he also appeared during he was in judicial custody, and learned court below also granted bail to him in that case. Subsequently, this case is same grounds, only implicating section 3 of the SC/ST Act. He has been arrested. All the sections are below 7 years, up to 7 years, Lordship. And if they requires, they must send a notice under section 14. Without anything, they abducted the person from the jail gate of the district jail and brought him to the police station without following any procedure of law. Subsequently, they have given the section 47 and 48 of the notice, and that arrest memo was given at 4:50 at the time of production. The petitioner before the learned CJM Morigaon, Lordship. All the norms and procedures have been violated here, and he has been arrested one after another in the name of all post. It is in some cases there is an decisions of the Honorable Supreme Court also how to arrest the petitioner to any person in connection with any cases. In this case, Lordship, it is because the wife of the petitioner, wife of the informant had already filed a lodged an FIR before the Dispur police station, and subsequently he was granted bail by this honorable court. Again, on the same allegations, Lordship, he has been arrested in connection with this case. I only implicated section 3 and R, which is not applicable in this case. They cannot produce. They will mention one public space. He never gave any public space on 26/12/2024, Lordship, because whole day he was, because that was the vacation time of the, because he is an advocate of the Guwahati High Court, and he was in vacation that time, and he never went for any public space on 26/12/24 as alleged in the FIR, Lordship. And at the time of production of the petitioner before the learned, they failed to show any contents of the public before the learned magistrate Morigaon, Lordship. Now they only mention about that is allegation against 29/24 regarding a tweet. For that, he has already been granted bail by this honorable court, Lordship. How they can, it amounts to double jeopardy, Lordship. He has been falsely implicated one after another without following any procedure of law with political vendetta, Lordship. In this connection, the petitioner also lodged FIR before the petitioner's mother lodged FIR before the DGP, because in that case, in abduction, the SP of the Morigam PSC himself is involved. That is why he has filed lodged FIR before the DGP, and they have made only GD entry, nothing has been there. That is why, Lordship, one after another case has been registered against him, falsely implicating him. And there is some guideline decision direction of this honorable court also, because he cannot come out from 15/3/2025 till date, Lordship. He is languishing jail in different jail. First, not Lakhimpur case, Lordship. Subsequently, he has been in Morigao district jail till today. And in this case, Lordship, kindly turn to page 92, annexure 15, Lordship. All sections are below the 7 years. How, without any giving notice, without any inquiry, immediately they have registered the case and arrested the petitioner from the jail gate, Lordship. In this connection, we also filed a writ petition before the Honorable High Court, alleging this infringement of his personal life and liberty of the petitioners. And in that case also, the Honorable Court issued notice, Lordship. Annexure 15, Lordship, this is our affair from the side of mother of the petitioners. How they have abducted the petitioner from the jail gate. If anything required, they must send a notice under section 14(1)(a), if necessary, and inquire the matter. Without anything, only political vendetta, they has been arrested in connection with this case, Lordship. That is why, Lordship, I pray, because I am cooperating in every cases, earlier cases also. Yes.
Here, you also will kindly turn to page 42.
42.
43. There 43 Lordship is not relevant. Next page 44 Lordship will see regarding this arrest.
Yes.
Yes. Also, the third paragraph, Lordship will find the IO in his prayer. Lordship has found page 44. Yes, Lordship. The IO in his prayer stated that the accused person needs to be interrogated as he has already delivered public speech on 26/12/24 at Beltola, making a statement that persons from SC/ST community, without having any quality controlling the public on the strength of reservation. The IO has also stated that the accused person has been spreading misinformation with an intention to malign the image of the complainant, who is a known person in the society, in the name of his caste. It has been further stated there is a high possibility that if the accused person is not kept in police custody, that he would make inducement, threat, or promise to any person acquainted with the facts and circumstances of the case. So and so. Next page, Lordship will find just 45 Lordship, next paragraph. The learned PP so and so has submitted that the accused person has a habit of making caste-based inflammatory statements, out of which latest being the public speech given on 26/12/24, in which the accused person reportedly stated that the unqualified SC and ST people are ruling the state on the strength of reservation. The learned PP submitted that the custody interrogation is so and so. I will not go into all this, Lordship. Next page, Lordship, will come to page 46. First paragraph, Lordship, the defense counsel have submitted written objections against the prayer for police custody, stating that the accused person was already arrested in a case filed by the wife of the instant complainant in dispute PS, in which the accused person has already granted bail. So this is the same argument that has been forwarded before your Lordship. Further, in the North Lakhimpur PS case 91/25, all his electronic belongings so and so has been given. Now, after considering all this, Lordship, he was forwarded to custody, Lordship. The materials are there, Lordship. Both the affairs are different, Lordship. This is in relation to a public gathering. And Lordship has already seen that in his statement, he has given a declaration, Lordship, that he is an advocate and also a spokesperson for a particular political party. Now, Lordship, we are not going to all those things, Lordship. But Lordship, being a spokesperson or an advocate, if he wants to make some statements regarding government policy or decision, that is okay, Lordship. But making statements against Brahmins, Lordship has already found baseless allegation now against ST people, against women. So it seems Lordship is a habitual offender. And what are the police supposed to do, Lordship, if someone is making such derogatory remarks against everybody, Lordship? Law will take its own course, Lordship. He has been arrested fair and square, Lordship. There is a case against him. So at this stage, Lordship, all these facts cannot be gone into your by Lordship without the perusal of the case there. So Lordship will kindly call for the case and fix a date.
Lordship,
After
habitual offender, how my learned friend is, can state that he is jailholding. It is an allegation. In different cases, they have made allegation against the petitioner in different manner. And this post is, he mentioned about the post of 29, 2024. And subsequent post is was public speech mentioned, but they failed to produce that public speech, contents of the public speech. It is in public domain. Why they failed to produce before the learned magistrate, Chief Judicial Magistrate Morigaon Lordship. And regarding habitual offender, my learned friend cannot say anybody, any habitual offender on the mere allegation in the FIR. He must be convicted in the court of law, or state, if the government declared that he is an habitual offender, then only they can state that he is a habitual offender. He is practicing in the court, he is cooperating every investigation. Thereafter also they have all the they have lodged the FIR for the post of 2024 Lordship. And they are prepared another FIR. They will he will arrest again Lordship in connection another. We know about that. What is going on, Lordship? This is the type of practice in regarding, he has also liberty. He has also liberty. If he is involved in any case, it will take it in own course. But without anything, he has been implemented one after release immediately. It is defying the honorable courts order. In this case, earlier cases, Lordship, interim bail was granted. In 2 cases, he will cooperate with the investigation.
See, that's what I want to say, that in 2 cases, most probably interim were granted. But it seems that he is, making such statement, maybe post maybe of 2024 or whatever. But in this case, not only post, it was a public speech also, as alleged. I'm not saying on as alleged. So CD will be required, I think.
Lordship,
Without perusal of the case diary.
Then I may be allowed to withdraw my petition.
You want to withdraw this one?
Yes, I may be allowed.
Okay, withdraw. Prayer for prayer made by so and so to withdraw the case. Same has been allowed. Petition disposed of on withdrawal. Okay, this will disposed of on withdrawal. Okay.
All right.
of supply list 1.
With liberty.
No, liberty means what kind of liberty now you want to say? You are in, this is not in any technical error or only non-granting or non-granting of interim bail, you are going to withdraw. So we cannot say definitely you are at liberty. Any petition, especially the bail petition, obviously you will be at liberty. There's no bar at all. No bar at all. Okay.
May I please, your Lordship?
Yes.
Lordship, here in this case, Lordship, though I have taken 2 grounds, Lordship, but one of the ground is, Lordship, non-furnishing of the grounds of arrest to the petitioner, Lordship.
Otherwise, your petitioner is in custody?
Since 9 months, Lordship, the petitioner is a driver of a courier service, Lordship. So his case is otherwise covered by the Lorikram judgment and Kulpam Malik judgment. But as because, Lordship, one of the ground is that, Lordship, may kindly fix this case on 7th, Lordship. And this today is the 2nd date, Lordship. On the last occasion, Lordship was dictating the order and directed me to furnish the certified copies.
You have already filed the certified copy?
Yes, Lordship.
Just to check up. The catastrophe is asking for 7th. Can it be?
Along with the one of the scales, 25 meters. Already works.
Can I get how we can? Can it be until 7th or 8? 8 can be otherwise. When matters. Now, fixed matter had already reached up to 25 or 30 in it. That's what we are facing. In fact, anyway, we're trying on 7.
Yes. Highly applies. Otherwise, Lordship, all the matters are similar kind of. It may not take much time. Highly applies.
Hearing may not take much time because later part we have to see they have to be typed, has to be checked out and corrected.
Yes.
So these are
That
the
is
other technical. Okay, we are trying.
Highly applies.
May I please? My lord, this matter related to the Zimma of a milk compound.
Here, GA Assam is also there. You are appealing or who is it?
Instruction awaited, Lordship.
Instruction awaited. Yes, they need some, most probably they require some more time, sorry.
Petitioner's livelihood depend upon that mill, my lord.
Livelihood?
This is a mill compound, my
yes.
lord.
Huh?
A mill compound, my lord, rice mill compound that was seized by the executive magistrate Morigaon, my lord.
Morigaon.
Sealed by the executive magistrate. That much only.
That was running unauthorized, Lordship.
No, my lord, that is really entirely wrong submission, my lord. That is not unauthorized, my lord. It is, we have the license, my lord. We have the license, my lord.
Definitely we'll discuss on those merits, but PP is also appearing here, na?
Lordship.
So basically, you have also submitted any objection here, Mr. Blocker?
Lordship, I have no objection, Lordship.
No. Have you filed any objection
No,
here?
Lordship, because I have to take instruction from the IO, Lordship, and we need an instruction. Latest instruction as well.
Otherwise, what is the, as per your instruction, Mr. Hussain, what is the, position of the, is still pending for the investigation?
It has been seized by the district commission, district authority.
No, that's what. The case is still pending at the investigation.
Charge sheet already filed.
Oh, charge sheet file, okay.
Yes, my lord, that is why.
Oh, it is already charge sheeted.
We annexed the charge sheet.
In the meantime, if a charge sheet has already filed, you can file your original objection, if any. And by that time, government advocate will also take instructions, if any. But last time also the order was passed for taking instructions, take instruction, whether there is any authority to seize the meal and all, and what is there.
If charge sheet is already filed, so I could not find it that the charge sheet is already filed, Lordship. If charge sheet is filed, then we need not to give any objection in that regard, Lordship, because already say whatever the IO's instruction is there, that is in the charge sheet, Lordship.
So obviously, basically, this is the case for this one. For it has already been sealed or by what?
Right, sealed.
Sealed. Now, for unsealing this one, I think you are Mr.
And colleague.
N. Polita. Heard Mr. M.K. Hussain, the learned counsel for the petitioner, and also heard Mr. N. Kalita, the learned government advocate Assam, and Mr. P.S. Lockhart, the learned additional PP appearing on behalf of state respondent. Mr. Kalita submitted in this regard that he needs some more time to take instructions in this regard. Prayer allowed. List the material when it can be listed, Mr. Kalita.
After election, after 2 weeks, Lordship.
After 2 weeks.
On 13th, my lord.
Should it be after 2 weeks then? Let it be after 2 weeks then.
Lordship, date may fix, my lord.
Fixing a date is a very problematic for us. All the matters we have to fix the date.
15, 16, any date, my
15,
lord.
16, 19. 19.5. So we are listing it on 19.5. 19.5 is obviously after election, I think.
Obviously.
What am I seeing? Oh, must be. All the matters are in this we had come. We are CDI has seen the photo.
Disciplinary bail petition that either is my minor other address, my minor daughter was eloped by the accused person, and the mobile phone which was with her that was also switched off till the date. So the real fact is-
Your daughter is not yet recovered, or
No, not more.
I mean, victim is not yet recovered.
Recovered. M. Hussain.
My lord, fact is that, my lord, there was a proposal in between the petitioner and the informant's family, marriage, my lord. But victim is, my lord, minor. So we requested them to wait till her majority. Subsequently, the girl has loved with another boy, my lord, and she fell away with another boy. But
So why your
and
petition is-
recovered.
But why FIR is lost against you?
FIR is lost against my lord me. After my lord fell away, next day she was recovered. Subsequently, we get the information, our family. So we refuse to accept their proposal. Hence, this my lord case falsely filed just to compel us. This is the thing, my lord.
But I don't think it is a case of interim, any interim. Call for the case diary.
Only this is the matter, my lord. My lord, I am a my lord.
Page 8, Lordship, page 8 is SRs.
Page 8. Yes.
Next day recovered, my lord. Next day morning recovered. She fell away with some other boy. Page 8, my lord, respectively beg to state that on 2/4/25 at about 5 p.m., my minor daughter Afsana Khan, aged over 16 years, came to shop from house. The below named accused person eloped my daughter forcefully. Thereafter, though searched, but I could not find out whether my daughter was concealed in unknown place. My daughter was though taken away mobile number so and so, but same is switched off. Therefore, your honor to investigate the matter and take necessary action. But the matter is that
So do you have filed anything in your petition to see that the girl has already been recovered? Is there anything? Her
That
statement
I have
recorded,
not.
or you have
That
not?
I have
Then
not.
if you go by
But
simply
I-
by the FIR, then still now she has been
But
recovered.
thorough affidavit, my lord, I stated that thorough affidavit, my lord, what I know the fact, my lord, what is happening. Actually, from 1 year, my lord, discussion was going on for marriage. And the informant family is waiting. I am also waiting. Though I am a major, I am also waiting. But in the meantime, the God has loved with another boy. We are not unaware of that, my lord. And that is why, my lord, when she fled away with that boy, and thereafter, though recovered, just to compel me, my lord, that is fine. If she did,
Within short date, Lordship, city may be covered.
so, my lord, protection may be given, my lord.
No, we are not in a position to say whether girl has been recovered because you have not submitted anything. CD call video.
On age 8, Lordship, short date. Or 13, Lordship.
So many matters nowadays. On 13th.
On 8, my lord, otherwise I am a small businessman dealing with my lord, poultry, my lord.
14, 14.5.
14.
Oh, 14.5. Let's take it on 14.5. See.
Yes.
50.
Your Lordship.
Yes.
Lordship, it is an anticipated bail application under 482 BNS, Your Lordship. The FIR vernacular is in page 16 and 17, Your Lordship. May I read, Your Lordship? প্ৰতি মাননীয় শুৱালকুছি আৰক্ষী থানাৰ ভাৰপ্ৰাপ্ত বিষয়া মহোদয় বিষয় এজাহাৰ গোচৰীয়া শ্ৰী জিতেন দাস পিতা পদকীয়া শ্ৰী বিপুল চৌধুৰী শ্ৰী হেৰম্ব চৌধুৰী মহাশয় সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজীৰ 7/11/2024 তাৰিখে উপৰোক্ত পদকীয়া দুয়ে মোৰ ঘৰত স্বৰ্গীয় মানিক চন্দ্ৰ চৌধুৰী পিতা গন্ধৰাম চৌধুৰীৰ নামত উত্তৰাধিকাৰী বিৰিত প্ৰমাণ পত্ৰ বিচাৰি আহে। উক্ত সময়ত মই বহুত ব্যস্ততাৰ মাজত থকাত তেওঁলোকে নিজে প্ৰমাণ পত্ৰ লিখিব বিচৰাত মই লিখিব দিওঁ। প্ৰমাণ পত্ৰ নং 478খন মই নিজে পঢ়ি বুজি চাই চিল চহী কৰি দিওঁ যদিও পদকীয়া দুয়ো পিছত উত্তৰাধিকাৰীৰ নামবোৰৰ বিপৰীতে ওৰফে শব্দ ব্যৱহাৰ কৰি আন 3জন ব্যক্তিৰ নাম লিখি দিয়ে। পদকীয়া দুয়োৰ বিৰুদ্ধে গাঁওবুঢ়াৰ প্ৰমাণ পত্ৰ জালিয়াতি কৰাৰ অভিযোগ. This is the thing, Your Lordship. Actually, a next of kin certificate was issued by the village head, panchayat head. So what happened, Your Lordship, the deceased person is the grandfather of the present two accused petitioner. The present two accused petitioners are both cousin brothers, Your Lordship. So what happened, this alleged incident is of, Your Lordship, 2/11/2024. And surprisingly, after 4 months, the present informant lodged the first information report on 23/2025, Your Lordship. So after 4 months, Your Lordship, of the alleged incident. So they inserted section like 337, 336(3) and 318(4) and 3(5, Your Lordship. The thing is that the accused number 1 is a cancer patient, Your Lordship, actually. So in the meantime, CD may be called for. I plead for the accused petitioner to go on interim, Your Lordship. Because the the alleged incident is of back of 4 months ago, and after 4 months, suddenly a FIR pops up, Your Lordship. This is the case. And the deceased person whose next of kin certificate is of forgery has been done, is alleged of, is the actually deceased is the grandfather of both this accused person, Your Lordship. So they are also keen.
But allegation that they have introduced the name of some more persons, I think, in the
Lordship, at allied sim, this one was allies word was used, symbol was used, and their pet names are also there, Your Lordship. That pet names were inserted, Your Lordship. Yeah. So this is
but,
the
if suppose some Urofe will be there or alliance will be there, then obviously in one name alliance so and so will be there. Then how?
He has also allowed him to write them themselves.
Yeah.
Yes, Your Lordship.
And otherwise, if they say this, it is not the allegation that the name which has been written by the informant was cut off and then some other present.
Yes,
It is
Your
that the name says so and so, alliance so and so.
Yes.
So how it will?
And the thing is that, Your Lordship, a third person is involved. The third person FIR name is there. A third person lodged this FIR, Your Lordship.
Who
Now,
is he?
He is the village panchayat head only. But the thing is that the interested person in that particular land, they have not come up with this FIR. Only the panchayat head, just because he was asking for money from this particular accused person, because government acquisition land was acquired their land, Your Lordship, and then they got a hefty amount of money. And in that position, this particular informant was asking money from this accused persons, Your Lordship. When they denied to give the money, he suddenly lodged this FIR. This is the case, basically.
People quite have heard. Your MSP.
J Das.
J
Das, Your
J
Lordship.
Das. Heard MS J Das, still on the concept for the petition, and also heard Mr. B.S. Locko, the learned additional PP, appearing on behalf of state respondent. Actually, he did this an application on section so and so in connection with so and so, considering the submission made by learned counsel for both sides. And with the fit case to extend the privilege of interim pre-release bail to the present petitioners till receipt of the case type. Okay, your body petitioner will be on the interim protection. Yes, lawful, when CD can be called for.
June, Lordship, June 3rd.
3rd of June,
Can be given. yeah,
fourth, fourth, 6. There will be some conditions, abide by all the conditions, appear before the IR and cooperate in the investigation.
Deeply organized. 60.
Yeah, please, your also is bail application in a POXO matter.
POXO,
Civil
notice করাই দিব।
PICSO.
For POXO is there. এই করাই দিব, issue notice করাই দিব খালি। It is still in custody. Oh, sorry, it is not a charge seated case.
PAS.
No, pre-arrest. It is not charge seated one. CTB call for it.
So notice will be also.
Notice has to be there. No, you take steps for notice within 2-3 days. The procedure is that only through the adjudication police station, routed to the office of the registry and the public prosecutor.
Next day, 9th.
9th, your will not receive tonight. Maybe by 13th, 14th, I think. 14th? Can be 14th. 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 You take steps.
Which
14th.
70.
May please, your Lordship. One of the clearest bail application here, the affair is phase 13. But the SI of the Golfara PS tells this affair against the 3 person arrested and present petitioner is apprehension of arrestment. The case is that on 9/4/2025, the informant got the information that IPL related gambling is going on. Accordingly, the police team visited the place and found the petitioner's shop. Petitioner has 2 employees. This 13 FIR name arrested accused person. 1 and 2, they are the employee of the present petitioner. And police went there, other person also went there and arrested them on the allegation that they are engaged with IPL gamblers. And thereafter, the police visited the present petitioner's house. And from house 9,57,000 was recovered. And saying that this money also IPL related. In fact, the present petitioner is a businessman. And his employee if something done, that is not the aware of the present petitioner. Because employee is running the shop, he just particular time visit the shop and that money except that money, nothing has recovered from the house So very unfortunate. He's a prestigious person So I may be allowed to protect on interim bail The maximum punishment here is the 3 years and the minimum is 6 months The IPL game 14 and 15. So that's my humble submission.
CD will be recovered also because Lordship, a huge amount of money has been recovered from his home Lordship. Apart from that, Lordship, his house the shop was also used for that purpose, Lordship. So Lordship, simply saying that he do not know about what his employee is doing. That may not be a ground, Lordship.
Yes,
So Lordship, at this stage, Lordship,
my employee, because I am the prestigious person.
Maybe Lordship,
I have a huge amount.
His shop is dying in that purpose.
This much money, I will reply. The 9 lakh rupees nowadays nothing. Since I am a reputed businessman, I have 2 employees also in my shop. So I may be protected with 3 minutes. It's not a serious case.
You used to keep a huge amount of money in your shop.
Not
nowadays, no one keep such a big amount of money in house.
From the shop only 30,000, that is the money of my employee. And from my house, in my absence, with the employee police came and from my house recovered this 9 lakh.
So you have kept,
I will reply
9 lakhs.
9 lakhs, the transaction every day is going on. Because I am a reputed businessman,
What kind of business?
I have IT file also.
What kind of business you do?
That
Except that grocery shop, do you have anything?
The grocery and not
Grocery and nuts.
Yes,
So grocery and nuts for transaction, you had a transaction of around 9-10 lakhs per day.
Yeah, more than this transaction is going on.
Nice.
So
okay, we are calling for the case diary. Yes.
Maybe
City-
protect, my lord.
No protection will be provided to you. Yes, Lawful,
On May 15 or
15th of
The
May.
allegation is nothing. Here is the IPL gambling, my lord, or suspect, my lord. Nothing related documents of IPL is recovered, my lord. Only for money, how police can suspect, my lord?
3 tickets were
My
also
lord,
found, Lordship.
kindly may protect the interim bail, but I'll reply, I will cooperate the investing agency, my lord. Only my humble
Listing it on
submission, my lord.
15.5, let us see case diary.
My
It
lord,
may
my
not be able.
interim protection will not hamper the investigation, so that it will be easy for the police file. Only that money, nothing is recovered, my lord. So how the police can suspect, my lord? Already my employee, my lord, arrested, my lord. They are playing or doing, my lord, I don't know, of their own capacity they are doing, my lord. Only I am the owner, they are the employee, my lord. So I have no this much internal relation with them, my lord. They are the salary-based employee, my lord. So my humble submission, my lord, kindly may protect, my lord. It is not a serious offense, my lord.
15.5, we are listing it on 15.5. CDB call.
Bail hearing item 18.
Tape records are.
May I please?
Updated case record is awaited, I think. You have not,
I have gone to the scan copy of the record.
actually, we call for the updated one.
My lord, in this case, my lord, the date of arrest, my lord, 10/10/2022, my lord. Till today, my lord, 2 years, 7 months is completed, my lord. And my lord, I have filed another
Otherwise,
additional.
any other case diary is there?
No, my lord.
No, scan copy is here.
Scan copy is received, my lord, and my lord, I have gone through, my lord, only 3 witnesses examined as on date, my lord. Out of 7, my lord. My lord, that is, my lord, what, my lord, the scan copy, my lord, that is reflected, my lord. But it is not up to date, my lord.
Scan
He has
copy
filed
was
an
submitted.
affidavit.
Pardon?
He has filed an affidavit, my lord, wherein he has annexed the evidence of PW3, my lord. Even, my lord, later, my lord, I have filed additional affidavit by annexing the deposition of the seizure witness, my lord. My lord, kindly come page number
No,
58.
deposition of the seizure witness means?
Seizure, my lord, when the police sees
Before
the,
court, before court.
No, my lord. Before the police station, my lord. The seizure list of PW3 to court. PW3, my lord. Before the IO, my lord. Police station, my lord. Kindly see the page number 48, my lord. Of additional affidavit, my lord. Additional affidavit 48, my lord.
Additional affidavit 40.
48, my lord. Annexure 9, my lord. Name is Suraj Singh. He is the seizure witness, my lord.
So this is before court only.
No,
before court.
What is? Yes, only before court, my lord. Already come LCM. Yes, my lord. My
No,
lord,
no, you're saying before police, before court. That's what
No,
I'm
my lord.
asking. Before court.
No,
This
my lord.
deposition is before court. No?
Yes, my lord.
That's what we are
Deposition, my
asking.
lord, deposition taken, my lord, before court, my lord. Trial court, my lord. The edition number 3, my lord. Yes, my lord.
This PW3 was examined on when?
No, no, no.
5th of October.
5/10/2024, my lord.
5/10,
No, my lord.
2024.
PW3, my lord. No, my lord. This is a PW2, my lord. Regarding 2, my lord, page number 48. And 50, my lord, PW3, my lord. I have annexed 2 witness, my lord. Deposition of witness, my lord. Can you see the page number 48? This is PW number 2, my lord.
No, we are on that. But question is that 3 witnesses examined.
Yes.
Do you have any
Out
other
of-
instruction?
Out of 3, I have submit the deposition of the 2 witness, my lord. I have enclosed, my lord.
One you have, why you have left one?
No, my lord, that time I did not receive the that deposition of the third PW3, my lord.
You have here you have annexed PW2 and 3. I am asking why you have not annexed the PW1. You are just saying by yourself that you have annexed
Yes, my
PW.
lord, that I have not
Why?
submitted.
Why?
Due to not record, my lord, received, my lord, by the junior, my lord, the trial court, my lord.
No,
My lord,
PW2 and 3 you have received.
Received, my lord.
Those were subsequently recorded, and PW1 you have
My
not
lord,
received.
Record is available, my lord. Report come already, my lord. In record.
No. Why you have not annexed? That's what I am asking. Why you have left the PW1? PW1 you have not annexed,
Yes,
isn't it?
My lord, can you see the, my lord, page number 48, my lord, according to the deposition of the witness, my lord. Last para, my lord. Page number 48, my lord.
Do you have any instructions till date? Because it is not updated, that's why we are calling for the updated. It has not been received. Can you tell us the present status report, or is there any witnesses examined?
No, my lord. In the meantime, no witness examined, my lord. Next date fixed, my lord, to 2nd June of 2025, my lord. 2nd June.
No, after
Next day.
PW3, is there any witness examined?
No, my lord. Up to 3, my lord. 3 witness examined, my lord. Till today, my lord. Next date, my
3
lord.
witnesses examined.
Yes, my lord. My lord, according to my lord examination, my lord, of the period, my lord, here, my lord, clearly mentioned, my lord.
Out of which, how many witnesses?
7, my lord.
Out of 7.
Only 3, my lord, examined, my lord. In the 2 years, 6 months, 18 days completed, my lord. Length detention, my lord. My lord, is a very important, my lord. And this is the page number 48, my lord. 48, my lord. I do not know the accused person by name. The incident occurred in the year of 2023, whereas the incident was happened 2022, my lord. This is the eyewitness, my lord, Caesar witness, my lord, saying. At about 4:30 and 5 p.m., some RPF personnel seized ganja in front of my canteen at Kamakha railway station. The accused person were taken to the PS along with the seized contraband. I put my signature in the search and seizure list at PS, my lord, police station, my lord, where the contraband was recovered, my lord, at the platform of 4 railway station, my lord. But Caesar witness, my lord, put the signature in the police station, my lord. Now, my lord, pros. When the accused person were apprehended, there occurred a gathering and I went there to see the incident. I had not seen when the seized materials were wet, my lord. Without seeing, my lord, the Caesar witness put the signature. This is very...
No, he is saying that when weight was taken, at that time he was not.
No, matter here clearly mentioned, my lord. I have not seen when the seized material were wet, my lord.
That's what I'm saying. When weight was taken, at that time he has not seen.
Yes, my lord. He was not present, my lord. Without
No,
present, my
when
lord.
weight was taking, at that time he was not there.
Yes, my lord.
Anyway, yes, go.
My lord, kindly consider, my lord, length of detention, my lord. 2 years, 7 months, my lord, sir.
Yes,
My lord,
prove.
commercial quantity ganja, my lord.
Mhm.
Charges frame on 4/3/2023, my lord.
Charges on 4/3.
4/3/2023, my lord. And PW1, my lord. He was examined first, my lord. 17/7/2023, my lord. The PW1 is the FSL authority, my lord. So he has proved the FSL report, my lord. It is positive test for ganja, my lord. Now, my lord, PW2 and PW3, my lord, these are the Caesar witnesses, my lord. But this contraband was recovered from 3 persons, my lord, including this present 3 petitioner, my lord. And my lord, in PW2 and both PW3, my lord, they have stated that it is recovered and seized from, my lord, all the 3 persons, my lord. Not specifically mentioned that, my lord, is recovered from this person, my lord. So, my lord, this is the update, my lord, and my lord, present status, my lord, is not up to date, my lord, as part is can be, my lord. But my learned friend is, he has annexed, my lord, PW3, my lord, which PW3 was examined on 5/10/2024.
Note position, not on this. Okay, ma'am, pass the order. We'll
My lord,
pass.
kindly
Any other
consider-
submission?
My lord, kindly consider, my lord, length of detention, my lord, 2 years, 7 months is measured. 2 years, my lord.
Section 30 will also come by.
Yes, definitely.
Disposal, my lord.
I will pass the order. Yes, disposal.
Oblige, my lord, may I submit, my lord? Judgment, my lord, judgment, my lord.
Item 19.
May I please your lordship, my lord? My lord, this is an application, my lord, under section, my lord, 483 of the, my lord, BMSS Act, my lord. It is a, my lord, he was, my lord, arrested on 2/4/2023, my lord. And 24, my lord. He is behind the bar for 1 year, my lord, about 1 month, my lord. Here in the instant case, my lord, first, my lord, your lordship, kindly look to the, my lord, charge sheet, my lord. Page 37, my lord.
Your lordship kindly read to the Assamese version, my lord. Page 46. Second paragraph. Second paragraph. Page 46, my lord. অভিযোগ পত্ৰৰ লগত ঘটনাস্থলীৰ এখন ফলমূল মানচিত্ৰ, জব্দনামা আৰু অৰিজিনেল FSL report গাঁঠি দিয়া হ'ল. There are only 3 documents they are relied along with the minor search sheet. One is the sketch maps, another is scissor list, another is original FSL report, my lord. Then, your lordship, I want to show something, my lord. I want to show, my lord, if your lordship go, my lord, then next page, Annexer 6, page 50. Point number 17, my lord. Whether magistrate has allowed the application move under section 52A mentioned details, nothing is available, my lord. And it was a, my lord, fact that I want to show another thing, my lord. When ganja was recovered, my lord, at that time, my lord, initial test kitting was not done, my lord. Your lordship, kindly go to the Annexer 9, page 77, my lord. Right? Point number 5. Result test done if any drug detection kit? No. Now I have come, my lord. There are 3 witnesses were examined, my lord. I want to show something, my lord. PWT is the expert, my lord. Ito na yung atas. Ito sa atas. Goting na kalagay dito. Ito sa dito. Mo dagdag nito ito office no. Let's kindly come to this evidence. Experts say, I do not know whether it is under the NDPS substance or it is come in drug and cosmetic and other thing, my lord. I read that, my lord, PWT cross-examination for accused Jagjit Singh. I have received one sample. Have you not got it? One sample. I have not seen forwarding letter sent by sending authority before the court. Only morphine was found after the testing. If the morphine is below, my lord, 12%, my lord, then it is not come under NDPS. I have some, my lord, document also. It was come 8%. I do not know whether the percentage of fire do not fall under NDPS substances. I have not mentioned about the color test in my report. It is not a fact. It is not a fact. Next, I do not know whether the percentage I found morphine fall under drug and cosmetic and not under NDPS Act. I do not rule the narcotic drug substance rule. Expert is not sure whether the substance is NDPS Act or not. Second, 52A certificate is not available. I have already shown your lordship that in Sarsi they are not rely 52A certificate. And expert opinion, another thing is that last thing is that, my lord. Yes, my lord. Page, my lord, just before that page, cross-examination of Gurmail Singh. I did a sealed envelope was containing signature of my any authority. I have not mentioned in my report whether test memo was attached, the sample or not. In my report, there is no mention of a procedure I have followed. I have not seen remnant sample before this court today. It is not a fact. My report is not conclusive. It is not fact. Report is not related present case. This is the case, my lord. Ganja was never produced before the court, my lord. Despite that, there is an order, my lord, last. You have to produce ganja. That was never produced before the court. Opium, my lord, sorry, my lord. Opium, my lord. My humble submission before your lordship is that, my lord. Since, my lord, if your lordship go through that, my lord, only 3 witnesses were examined, my lord, out of 11 witnesses, my lord. Expert has categorically stated that this, my lord, this thing is, I cannot, my lord, ascertain whether it is a NDPS substance or it is some other substance, my lord. Expert has categorically stated, because, my lord, Kani, my lord, your losses know very well, my lord. There are 5 things available, Kani. Morphine, codeine, aru ketaman tan shobd ase na. Pescavin, noscafin, and necrotine. They were not tested, only morphine were tested. And it is 8%. If you also go to the report, I have some document, Mala, who said below 12%, it is not fall under the NDPS Act, Mala. I shall produce you before your lordship. This is my submission before your lordship. 52A, my lord, is not available. So, my lord, 52A is not relied upon by them, my lord. So, my lord, as per my lord, Mohanlal, my lord, and Mangilal, that will be follow, my lord. Secondly, I have a judgment, my lord, where 1 year, 1 month, if the test was not examined, my lord, the long incursion bail has been granted, my lord. There. I love custodian. I'll have to go this way. It's an alarm. They love custodian. September, I go like bloody. This is the judgment, my lord. Lawful speckle, my lord. In that judgment that has been granted, my lord. And co-accused is released on bail, my lord. I have filed a, my lord, petition. Of course, that is, my lord, under section 50 and 58 CRPC, my lord. I have filed a, my lord, additional affidavit, my lord. In that section 50 and 58 CRPC, co-accused has been released on bail, my lord. If your lordship allow me to submit, my lord, because as your lordship fixed that in this section 50-50. If your lordship not satisfied, I am going to that. I want to say something, my lord. That what is the law about that, my lord? My learned PP has submitted, my lord. Once, if your lordship in already co-accused case stated that fundamental right has been violated. If
Mr. Chaudhary, we are listing some of the matters
Yes,
we have
ma'am.
already heard, I think.
Yes, my lord.
So those matters
my
we are
lord.
not going to hear.
Yes, my lord. The whole case has been originated by the, my lord, government advocate, my public prosecutor from that hit and run case, my lord. In that case, your lordship will see.
That has already been submitted by many advocates.
I want to submit something, my lord. Something different, my lord. They have
Oh, it is
originated.
different.
On that case, my lord, interim bail has been granted. Why, my lord? Because court has not decided that fundamental right is not violated. They want to say, my lord, it was whether it was Honorable Justice Gavai has appearing, my lord, to send it to the larger bench. Matter will be sent to the larger bench, or the other thing, my lord, matter will be sent larger bench. Suppose, my lord, that judgment has been reserved, my lord. And, my lord, one of the judgment, my lord, for I am not on that, my lord, on academic discussion, my lord. What is the law has been said, my lord, of the apex court. Para 14, my lord. Para 20, one say? 29. 29, my lord. I am reading that, my lord. Only reading that, my lord. 29 says, as it was indicated in Harbhajan Singh case, para 29, page 329, my lord. The pendency of a reference larger bench does not mean that all other proceedings involved in the same issue would remain state till a decision was rendered in the reference. The reference has been made in Gyan Singh case need not therefore detain us till such time decision cited but not modified, altered, and hold the appeal. Till the, my lord, that judgment has been passed, my lord, that Bihan Singh judgment and Purkayasto judgment has been followed. In Bihan Singh, your lordship is very well. There is a direction to the, my lord, Honorable High Court to follow the Bihan Singh, my lord. As on today, my lord, that judgment has been followed. Another thing
Now
is
see,
that,
Mr. Chaudhary, we
Yes.
have passed many orders
Yes,
from
ma'am. Yes.
last, mostly
Yes,
from
madam.
1 month or more than 1 month.
Yes,
We
madam.
are passing many,
Yes,
just
madam.
many orders wherein the
madam.
bail were granted.
Yes, madam.
Now the question is that regarding this statutory right of 21 or 22
Yes, madam.
of the Constitution, those were considered and the bail applications were granted.
Yes,
Now
madam.
subsequently, one issue was raised by the learned public prosecutor,
Yes, madam.
Mr.
Yes, madam.
R. Kaushik.
Yes, madam.
So that's why we have deferred some matters. Not only it is not the case
Yes,
that we
ma'am.
are deferring the matters
Yes, madam.
only for the orders of the waiting for the order of the Supreme
Yes,
Court because it is still
Yes, ma'am.
pending, and he has submitted, it may be sent
Yes,
before the
ma'am.
larger bench
Yes,
also
ma'am.
for the
Yes, ma'am.
decision.
Yes, ma'am.
So that is not our issue. Our issue
Yes,
is
ma'am.
that the
Yes.
orders should be
Yes, ma'am.
there should be a parity in the order. That's
Yes.
why most of the matters wherein specifically the grounds of arrest have been taken,
Yes.
I am deferring those matters.
Yes, ma'am.
Now,
Yes.
question is that there are some matters wherein there are some other issues were also cropped up, especially the incarceration is also there or some others. Those we heard and we are passing the orders.
Yes.
But the orders which have now your case, if you go by your case, it is seen that your petitioner is of 9 months in
No, ma'am.
custody.
1 year, 1 month, one judgment I have given.
Yes, 1 year, 1 month.
Yes, ma'am. And
And if you go by the speed of the trial, Mr. Locker will also say that here there 3 witnesses are already been examined within
Yes, ma'am.
1 year.
Yes, ma'am.
There are some cases wherein 3, 5, 4 years, even 4 years or even 3
Yes, ma'am.
years, 2, 3 judgments, witnesses were examined out of 12 or out of 11
Yes.
or out of 10.
Yes,
So
ma'am.
whatever. But
Yes, ma'am.
here your petition is, if you go by your case,
Yes, ma'am.
it is seen that the case is speeding up in a good pace. We cannot say because recording a statement of evidence of one witness in NDPS,
Yes, sir.
it takes times. Because I am from the lower judiciary, I
ma'am.
know
Very well.
because it takes times.
Yes, ma'am.
Maybe for the whole day, one matter may be there,
Yes, ma'am.
one evidence
Yes,
recording.
ma'am.
So there may be some reasons because as we go by but yes, your petition case is also raised on the 50 and 50A or whatever.
Yes.
52 is also there.
Yes, ma'am.
Those petitions can, if there's, and then otherwise we are deferring the matters. That's what. It's
Yes.
not the case
Yes,
that we are
yes,
waiting
ma'am.
for
Yes,
the
ma'am.
judgment of the
Yes, ma'am.
Honorable
Yes.
Supreme Court for
Yes.
which
Yes,
would be
ma'am.
passed by the
Yes,
Justice
yes,
Gavai.
ma'am.
And Mr. Ahmed, advocate also
Yes.
pointed out that in para 45 of the said Bihan Kumar, it is well settled and well just a written communication has to be there.
Yes.
But when the issue was raised regarding the court red-handed issue,
Yes,
that's why we are waiting whether this is applicable or not.
Yes, yes, ma'am.
So that's why we are deferring,
Yes,
in
ma'am.
fact.
My humble submission is something different, madam. I am not 50-50, madam. Your lordship different. Your lordship has said 3 witnesses were examined, my lord. Prima facie case, my lord, whether it is made out against the petitioner, particularly when PW3.
So if you
expert has
insist,
said.
that's
No, I am not insist.
no,
madam.
no, no.
Yes,
If you want to raise
Yes, sir.
the argument on that point, then it may be heard and order will be
No,
passed
madam,
accordingly.
50-50, my lord.
50-50
I
also.
always obey your lordship.
No.
Yes,
If you want to
Yes, ma'am.
praise
My
it out,
humble submission of the public prosecutor is that, my lord, sometime what happened, my lord, that I am one judgment issued AR 1980 SC 1980, paragraph 5, categorically state, if the court thinks that fundamental right has been violated.
yes,
pleading-
obviously.
the pleading is not necessary. What my learned public prosecutor always said, that we need some time. It is the duty of the state to show that his fundamental right was not violated at that time, my lord. That time. my
But
lord.
there are some
Yes,
judgments
yes,
also
my lord.
wherein
Yes,
it has been
Yes,
held
my
by
lord.
the Honorable Supreme Court
Yes.
that if it is a case of suppose commercial quantity or whatever the gravity
Yes,
of the
my lord.
offense,
Yes, my lord.
long incarceration may not violate by the Article 21 or 22.
Yes,
There,
ma'am.
these kind of orders are also there.
Both type of
So
order is
both in
there.
both ways. So,
Yes,
but
ma'am.
now we are specifically emphasizing on probate forecaster Bihan Kumar as well as some other
Yes, ma'am.
assessors.
Yes, madam.
So he is insisting on some cases on that day for Pankaj Bansal is also there and Bansal is there. So that is the issue.
Constitution, one seeing judgment, my lord, is no.
Hmm.
Article 22(5), my lord, that has been flowed to the Bihan Kumar, Probate Forecaster, then to the Bihan Kumar case. So it has to be, my lord, go to the Constitution. Ultimately, it will go to the larger bench, my lord. My correct understanding of law, because as per my lord, that case, my lord, official liquidator, same forum, my lord, 2 judges bench cannot, my lord, override that two judges order, my lord. It have to go to the constitutional bench, my lord.
Obviously.
That is the law, my lord. Anyway, my lordship, fees not only short that may be given. my
Apart
lord.
from that, Lordship,
No, just on, yes.
why we are submitting, why we are stating that Lordship, regarding the court attended case is something different, Lordship. And when his advocate is already appeared on behalf of him, that is different, I think, because the judgment itself says, Lordship, the Honorable Justice N.K. Singh's judgment, Lordship, the para 3, Lordship, may kindly see, there is a line, Lordship, therefore, the purpose of communicating the ground of arrest to the detainee and in addition to the relatives of as mentioned above is not merely a formality but to enable the detained person to know the reasons for his arrest but also to provide necessary opportunities to him through his relatives, friends and nominated person to secure his release at the earliest possibly opportunities for actualizing the fundamental right to liberty. So, Lordship, what it means, what I can understand also from the Lordship, the purpose of this article is to enable him to so that he can protect himself, so he can defend himself before the court of law. In some cases, we have found Lordship, when the honorable court below, planet court below has asked him, put some questions, whether you are aware about the offenses you have been involved. He says yes. Thereafter, sometimes he engages him advocates, Lordship, on the same day. Then in that case, Lordship, his right has not been violated, Lordship. All these aspects has to be, we have to see, Lordship. That is why we are submitting, Lordship, that whether in court in that cases there are some cases different from that judgment or not, Lordship.
May I submit, my lord?
That
Only
is
one
para
line,
3,
my lord.
Lordship.
But my learned and Honorable Justice Koteshwar Singh has said, my lord, that is that Article 22, subsection 2, my lord, informing to the my lord, next kin, my lord, not Article 22, 1, my lord. Ground on arrest, my lord, this is basically come preventive, and other, my lord. In many cases, I have appeared, my lord, in Kofe Prasad and NSA cases, my lord, with my senior, my lord. It is that you have to communicate it on writing. I can produce the judgment, communicate it on writing, ground of arrest, not that. I have, when the time magistrate has asked something, it is not the duty of the magistrate, it is the investigative officer duty, my lord. I shall also produce all this judgment, my lord. Because, my lord, it is, my lord, fundamental right question is there, my lord. Your lord say kindly fixes, my lord, short date if possible.
Short as a whole, we don't have any such kind of short date because these matters are already been fixed. 25 matters in 20, I'm on 5th, I think 26 matters and in 27. So we are not keeping you that on that footing. I didn't think it may be on, no, pardon?
Because, my lord, if your lordship
No,
30
whatever.
May, a judgment has been passed by your lordship, that will affect my case, my lord.
Oh, that will affect every case.
So, my lord, your lordship kindly allow me to, so that I can also submit my case, my lord, on my lord. On first
It
May.
may affect your case also, may not also.
Yes, my lord, first May, my lord. So,
No, first May, not possible at all. First May, second May, not possible.
so I can also argue my case also. my lord.
Already in second May, in that line, we have fixed 25 matters. See, how will you write and how will you pass the order? Your submission may be recorded, but we have to pass the orders have to be checked, it has
So
to be
your lordship,
uploaded.
pass
All
an
the
order
bail
together.
orders are nowadays is up to running up to 13,
My
14
humble
pages.
submission before
Not
lordship,
below 10,
if your
not
lordship
more
pass an
less than
order,
10.
my lord, then my case, my lord, will come.
Okay, that may affect you, otherwise I don't know.
That is why, my lord, my submission before lordship, your lordship may be.
9-5 মান করে দিন, নাকি মান করে দিন? 9-5.
My lord, if your lordship give that, see, my lord.
9-5. 9-5 you have district.
My lord.
What to do? There may be
Because my
some
lord,
cases.
31st, if some law will not come, all other will also pass the order together, my lord.
9-5 we are listing it up.
My lord.
Family.
21.
Status report was called for in that.
Yes, ma'am. Because the board was called. They received, my lord, charges frame, my lord. Charges frame, my lord, on 19 charges frame. And the next date was fixed on 5. Has to be the 19. 19. 19. 19. This month, sir.
far as my lordship will remember, my lord, this is a murder case, my lord. A girl was killed, my lord. There were eyewitnesses. Because allegation was that, my lord, she is having some relationship with the father of the my lord,
Father of
this
the,
accused.
yes.
There are eyewitnesses, my lord. I have gone to the scan book of the record, my lord. Sufficient evidence collected by the IO, my lord, before filing the search warrant, my lord. So at this stage, my lord, I am opposing, my lord.
My lordship, submission is that 6 months or more than 6 months he has been in jail. And
Now, if you go by it's a very brutal murder. In fact,
yes, my
it
lordship,
was a
here-
pre-planned
here
murder
very-
also. So far I can remember,
Yes.
the girl was very brutally murdered. There are eyewitnesses also, so I don't think at present.
His allegation is only that he has some some help. He has given some logistic help.
That is, he is also
Conspiracy
one of the
there,
person who is the
conspiracy was
conspiracy,
there.
involved in the conspiracy.
Yes,
That is
ma'am.
why. He may not be the executor, but he is the conspiracy was there.
My lordship,
So how many petitions you are representing?
I'm even one.
One.
Yes.
His son.
He's the son of
Son. He is the son.
No, he's not the son. Or son of man, the son is already got bail, my lordship.
He's not the son.
Already 5 person has been charged sheeted. From them, 5 have been enlarged on bail, my lordship, by this court.
Then how you are there?
No, 3 জন পাবে।
3 got bail.
3 got bail.
Most probably father was the person I
Yes,
allowed
father
him
is
on
not
bail.
necessary, no, my
So
yes.
he against father also search it is there or no?
No, he will discharged
He is
due to
discharged.
insufficient of evidence.
Because he was not there. I dealt with the case of father, I think, initially.
Lordship is the bail.
Yes, I allowed the bail.
Till today, my lordship, 189 days, it's more than 6 months. My lordship, a fair chance to be given to defend this, and there is no chances of tampering with the evidence and with witness and evidence, my lordship. This immovable and immovable property is there, so it's safe in that place on the house. Page 55 of the kindly bail.
Please.
Page 55 of the bail.
Yes.
These are the part of the search matter.
Hmm.
So from second paragraph, also make peruse matter.
Yes. The eyewitnesses.
They have identified the accused matter. This is the matter accused petitioner matter. Songya wrong matter.
So he was present. So he took the very active part in.
Madam, I was a solicited case, my lord. So the lordship will have to consider his bail application on merit, my lord. The solicitor's case,
Lordship,
secondly,
I'm
my
not
lord,
on
the
the merit
charge
of
has
the
already
case.
been framed, my lord. At this stage, my lord, if they are released on bail, my lord, they will hamper the investigation, my lord. And there is only one eyewitness left, my lord. If he is, my lord, detained or my lord, if he is killed, my lord, then there will be no evidence, my lord.
There is no chance in my lordship. I'm not merit of the case, my lord. Already the co-accused has been enlarged on bail and the laying of detention more than 6 months, my lordship. I'm on that, my lordship. I'm not on merit of the case, my lordship.
Grounds of merit will not come in each and every case, especially on this type of nature of big case. If there is a murder case, my lord, the gravity of the offence has to be looked at.
Yes, my lordship. But a fair chance, my lordship, to defend his case.
Heard Mr. A. Fupon, the learned counsel for the petitioner, and also heard Mr. R.J. Purva, the learned additional PP, appearing on behalf of state respondent. Scanned copy of the LCR along with the present status report has been received, wherefrom it is seen that the case has already been, the charge has already been framed against the accused persons. Next, Mr. Fupon, the learned additional PP submitted in this report that the present accused petitioner is behind the bar since more than 6 months and charge has already been framed against the accused persons. He further submitted that the co-accused persons have already been granted with bail and hence, considering the case of the present petitioner on the same footing, he may also be granted with bail on the ground of priority. The accused being a permanent resident of his address locality, there is no chances of absconding or hampering or tampering with the evidences of record. He will appear before the court on each and every date to be fixed by the court. Next paragraph. Mr. Borba, the learned additional PP submitted in this report, as case has already been charged and charge has already been framed, the length of detention or cannot be the sole ground for releasing the accused petitioner on bail at this stage. He further submitted that on perusal of the case report as well as from the charge sheet, it is seen that the present petitioner took the active part in committing or executing the murder of the victim. He accordingly submitted that there is every probability or the possibility to hamper or tamper with the only eyewitnesses to the prosecution case, and hence he raised objection and submitted that it is not at all a fit case to allow the accused person to go on bail at this stage. Next paragraph. Considering this submission made by learned counsel for both sides, I have also perused the scanned copy of the case report and the statement made by the witnesses in this regard. It is seen that the present accused petitioner was found to be directly involved in the execution of murder of him, and the eyewitnesses also identified the present accused petitioner by name. So considering the nature of allegation brought against the present petitioner, the other matters in the case record, I do not find it a fit case to extend the privilege of bail to the present petitioner at this stage, and hence the same stands rejected. Your petition stands rejected. Chamber by the corona I just got a frayed infection. Subject to court. Pardon? Subject to court.
22.
Yes, 22. Here, the charge sheeted case.
No, but we have been informed, the charge has been submitted, my lord, but the number has not been provided, my lord. So may I patent, my lord, let the matter come up day after tomorrow, Thursday, my lord. The only problem is that, my lord, today is 83 days, my lord. So, my lord, if the charge sheet number is provided, my lord, then we can, my lord, apply this code about the, my lord, charge sheet number.
Yes, Ali, yes, what is?
My lord, already 83 days behind the bar. And on the other hand, since the charge sheet has been laid by the concerned investigating officer, it means already perhaps section inserted 8 instead of 4.
Instead of 4, 8
As
is-
per contents of the FIR, 4 does not come. If 8 comes, then 3 years imprisonment.
Now, as per your instruction, do you have any instruction that it is 8, not 4?
No, as per
that
contents
will-
of the FIR made in the FIR. my
That
lord.
will depend from the case, my lord, charge sheet, my lord. Now, while registering the case, my lord, section 4 was.
But his submission that it should be 8 otherwise.
8, my lord. But when the charge sheet is submitted, it might be 8 also, my lord. So lordship may call for the skin with my lord, otherwise, but my lord, for that purpose. my
Scan
lord,
copy, even if suppose charge sheet is not before the
Yes.
court down, court below, then scan copy will not
Then, my lord,
help
let it
you.
come here, sir.
Day after tomorrow, do?
My lord.
We'll provide the charge sheet.
Okay, provide the charge sheet number and as well as the section under which the case has been charged sheeted. So you are appealing for the response number 2. Naam kita di that he is appealing for the response number 2. MFS MK1. Please the matter on day after tomorrow is means 30. 30. Okay, pay listing.
23.
My lord, this is charge sheeted case, my lord. It's not
Yes,
behind-
service is still awaited here.
Service is everything.
Be appointed, my lord.
Pardon?
No,
No, service is awaited, then how amicus will be appointed?
340 days behind the bar. my lord. Trial is also going on already out of 15, my lord, 10 witnesses are examined.
We have to observe the formality, otherwise it's okay, you have sufficient period behind the bar and that too 15 of 10 numbers of witnesses are already been examined, including the victim and the informant. All have been,
Examined, my lord.
all the witnesses.
My lord, 10 witnesses examined, my lord, but in the, my lord, charge sheet, my lord, 15 witnesses cited, my lord.
How many?
15, 1-5. My lord, what I found, my lord, was IO, the medical officer, the victim, informant, my lord, other Caesar witnesses, everybody examined, my lord. Only 5 witnesses left, my lord. Whether, my lord, that will, my lord, court will decide it will require or not, my lord.
Mhm. All are examined otherwise. Otherwise, all the party witnesses have been examined.
Yes, yes. And there are materials, my lord. Victim is implicated. She is only 12 years old, my lord. Victim.
Then section 6 POCSO, no?
Yes.
And then can we heard the other side then, other than if the informant appears or what you want to submit?
My humble terms are, my lord, that that service report be obtained, my lord. Because
Can you take instructions regarding the service? Otherwise, 2 factors are there. One, that the girl is below 12 or 12 years old. She is a minor,
Minor.
undoubtedly. And
She has-
section 6 is there.
Section 6 is there.
And the otherwise, as he submitted that out of 15 or what, all the vital witnesses are already been
Already
examined.
been examined.
So that may be one of the kind of submission. So let the service be, you make an inquiry, we are keeping, listing it on.
So did my given only.
Yes, maybe on 2nd. You just make an inquiry on that day,
Yes,
we
yes.
may appoint an amicus. You are appealing to the MK Hussain, the learned counsel for the, sorry, KM Hussain.
Yes, ma'am.
KM Hassan, the learned counsel for the petition. And also heard Mr. R.J. Borba, the learned additional PP, appearing on behalf of state respondent. From the office note, it reveals that the service is still awaited for the respondent number 2. In that regard, Mr. Borba, the learned additional PP, is hereby asked to take instructions regarding the service of notice on the respondent number 2. Place the matter on 2nd, 2/5 of.
24.
May I please, your lordship? Pokso case, my lord.
Services complete.
Service completed, my lord, amicus may be appointed.
No one is representing to.
Yes, lordship, no one is representing. Sir. Today I have to take care.
Oh, you have appeared already.
Actually, I have right now.
Ah.
It's another date I will file your update.
We'll file, going to file. I heard Mr. G. Soman, Learned Counsel for the petitioner. And also heard Mr. B.S. Goswami. And also heard you are Mr. A. S. Islam. S. Islam, the Learned Counsel, appearing for the respond number 2, oblique informant. It is submitted by Mr. Islam that he has filed wakalat number today and required some more time to file his objection. Prayer allowed. This is the matter. When it can be you going to file? After
a week.
After a week. Yes, after a week any date. 15/5 will do. 15/5.
Obliged, ma'am.
Is the otherwise charge sheeted case?
Yes, lordship. Trial is going on already. Most of the witnesses are examined. Only doctor and police, they are
Yet to be examined. 15.
Obliged.
26.
Maybe the lordship. So regular verification lordship, charge sheeted case lordship. Charge frame under section 8 of the POCSO Act lordship. Lordship, notice was issued and office note dated 24/4/2025 indicates that lordship that report has been served lordship. No, notice has been served. And but the
Scan copy is awaited, I think.
trial court record is not received. We have to wait for that.
So no one appeared today for.
No one. So lordship may kindly appoint some amicus curiae to defend.
Today we are going to. Heard Mr. N. Hassan, the Learned Counsel for the petition. And also heard Mr. B.S. Lawford, Akis Goswami, the Learned Additional PP, appearing on behalf of state respondent. And office note dated 24/4/2025. As fixed as service is already completed on respond number 2. However, the scan copy of the LCR is still awaited. Issue reminder, registry will do the needful. Further, let R. Chaudhary. Accordingly, MS R. Chaudhary is hereby appointed as an amicus. Registry will do the needful in that regard. List the matter accordingly.
Short date may be given already 181 days behind the bar, lordship. Section 8. Lordship, that registry will be directed to procure LCR along with case data.
Yes, yes.
That observation was not there in last order.
LCR along with C to recorded. Yes. 14/5. 1.
Obliged.
27.
May I please, Your Honor?
Here we have received.
Because there was call for Your Honor.
It is a charge sheeted case or not?
No.
Not. So your petitioner is behind the bar since when?
I have already arrested in 93, 2025. And after custody, the police custody 5 days. And I have been sent to the 24/3/25. And till then, since then, I have already then custody, Your Honor.
So report from the IO lordship, this case dry in Honorable District and Session Judge Dorang Mongol, that's why he cannot produce that reply today.
It's lying there.
One thing also be there.
39 days already. And coitus, Your Honor, coitus already granted bail, Your Honorable Politics, Your Honor. In correction to BA number 1115/2025.
When a short date will try to produce my case.
You have Mr. Deca?
Seaborough.
Seaborough. I heard Mr. Seaborough, the Learned Counsel for the petition. And also heard Mr. P.S. Law Gusami, the learned additional people appearing on behalf of state respondent. It is submitted by Mr. Gusami that the report has been received from the IO, wherein it is stated that the case data could not be produced as same is lying before the learned district and session just Morika.
Dorang.
Oh, sorry, Dorang Mongol. The IO is hereby directed to collect the case diary and to produce the same before this court on or before this court on or before the next date of listing. List accordingly, yes, when it can be for
13.
13.
I have list.
46 of the supplementary list.
But here allegation is that the victim girl was missing. My lord, in fact, there was a love affair. And the petitioner and the victim girl went to their relatives. And after next day, my lord, the girl was recovered.
Next day, girl recovered.
Recovered. That is page 17.
Page?
17, 17. During investigation, that paragraph.
In this case, the charge sheet submitted.
Oh.
28 to 25.
When?
28 to 30. And my lord, I have also taken that plea of violation of fundamental right under Article 21 and 22. Last August, my lord permitted me to file additional affidavit along with certificate copy of notice. I have filed that.
You can take the plea because once charge sheet is there, we do not want to interfere in this case. So, because nowadays, as per my information, most probably the grounds of arrest, etc., taking into consideration by the learned, the trial court belows also. Because same
Here,
ground.
since we are here, my lord also can in
No.
terms of Bihan Kumar, my lord, it is.
It's okay, Bihan Kumar is there, but
My lord, there is Bihan Kumar, my lord, it is also held that mere filing charge sheet will not validate the illegality of arrest. It is clear.
yes, that's what I'm saying. You take plea before the learned trial court will. Filing of the charge sheet will not that validated the these are there. I have already did. So we have mentioned in our orders also that observation of the Honorable Apex Court. But the question is a charge sheet matter. That's why I'm saying that you appear before the learned trial court below and play before this one. Mr. So-and-so, the counsel for equity.
Otherwise, my lord may fix on.
Miss, you are Miss. I'm to know so-and-so appearing on behalf of Mr. T. Dury, the learned amicus curiae. And also heard Mr. P.S. Gusami, the learned additional PP, so-and-so. It is submitted by Mr. Gusami that the case has already been charge sheeted. Yes, fine. CS number?
CS number 15/25, dated 28 to 25.
बाकी ही लिख लीजिए अपनी. You appear before the learned trial court below with an appropriate application for bail. Take all those grounds also, non-mentioning of ground of arrest or whatever that may be considered.
My lord may give some observation.
No, the direction will be there, definitely.
Because in through additional affidavit, I have taken that clear.
Yes, obviously, I know.
MD.
Item 50.
5/0.
May I please, my lord?
Yes.
My lord, petition is being.
Here we have received. Sami?
Why not received that case there?
Huh? Record. LCR, I think.
LCR, my lord.
Yes.
Oh, LCR.
You want to see LCR here? Yes, doctor.
Yes, my
Submission.
lord. Yes, page 13, my lord. This is the vernacular Assamese, my lord. Assamese version.
1-3.
1-3, my lord. May I read, madam? সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী ছয়ঞ্চো তাৰিখে নিশা প্ৰায় ছয়ঞ্চোমান বজাত আমি পৰিয়ালসহ সোণাপুৰ থানাৰ অন্তৰ্গত পাতৰকুছি গাঁৱত বিহুৰ অনুষ্ঠান উপভোগ কৰি থকা অৱস্থাত মোৰ নাবালিকা ছোৱালী লুনা ডেকা বয়স 16 years madam ই দোকানৰ পৰা কিবা এটা কিনিব যোৱাত উপৰোক্ত পদকীয়াজনে মোৰ ছোৱালীজনীক বাটত আগুচি ধৰি নানা ধৰণৰ অশ্লীল ভাষাৰে গালিগালাজ দিয়াৰ লগতে প্ৰাণে মাৰি পেলোৱাৰ উদ্দেশ্যে ডিঙিত চেপা মাৰি ধৰে লগতে তাইক লাঠ ঘুচা মাৰে ফলত তাই শৰীৰত গুৰুতৰ জখম হৈ লগে লগে মই ঘটনাস্থলীত উপস্থিত হৈ মোৰ ছোৱালীজনীক উদ্ধাৰ কৰোঁ যদিও পদকীয়া পলাই যাবলৈ সক্ষম হয় পৰৱৰ্তী সময়ত মই মোৰ ছোৱালীজনীক সোধপোছ কৰি জানিব পাৰোঁ যে তেওঁলোক দুয়োৰ মাজত প্ৰেমৰ সম্পৰ্ক আছিল উক্ত সময়ছোৱাত পদকীয়াজনে কৌশলৰে দুয়োৰে কিছু অন্তৰংগ মুহূৰ্ত মোবাইলত আবদ্ধ কৰি ৰাখে আৰু পৰৱৰ্তী সময়ত পদকীয়াজনে উক্ত ফটোসমূহ সামাজিক মাধ্যমত প্ৰচাৰ কৰি দিব বুলি ভয় ভাবুকি প্ৰদান কৰি ছোৱালীজনীক মানসিক হাৰাশাস্তি দি আহিছে this affair my lord register under section my lord 323 554 341 294 and 506 IPC read with section my lord 8 of POCSO Act then after my lord the police my lord police had filed my lord charge sheet my lord page 20 my lord the Assamese version my lord page 20 page 20 তদন্তকালত মুঙৰ ঘটনাস্থলী পৰিদৰ্শন কৰি ইয়াৰ এখন সম্পূৰ্ণ নক্সা অংকন কৰাৰ লগতে মুঙৰ গোচৰীয়া আৰু সাক্ষীগণে এই গোচৰ সংক্ৰান্তত সোধপোছ কৰাৰ লগতে মই মোৰ নাবালিকা ভিক্টিমৰ লুনা ডেকাক জন্মৰ প্ৰমাণপত্ৰও জব্দ কৰি জিম্মাত দিয়া হৈছে তদন্তকালত মুঙৰ এই ভিক্টিম জনিক মাননীয় আদালতত আণ্ডাৰ সেকশন 164 CRPC ধাৰাত জবানবন্দী লিপিবদ্ধ কৰা হয় আদালতৰ আদেশমৰ্মে ভিক্টিমজনিক তাই দেউতাকৰ জিম্মাত দিয়া হৈছে আনহাতে ভিক্টিম ডাক্তৰী পৰীক্ষা কৰোৱাৰ বাবে গুৱাহাটী GMC লৈ প্ৰেৰণ কৰা হৈছিল যদিও ভিক্টিমজনীয়ে নিজ ইচ্ছা মতে ডাক্তৰী পৰীক্ষা নকৰো বুলি প্ৰতিবেদনত লিখি দিছে তদন্তকালত এজাহাৰ নাম থকা পদকীয়াগণ ৰাহুল তুমুং পিতা সোয়েঞ্চো ৰেচিডেন্ট সোয়েঞ্চো থানা সোয়েঞ্চো জিলা সোয়েঞ্চো বিৰুদ্ধে জড়িত থকাৰ অপৰাধত সাক্ষীগণে প্ৰমাণ কৰি পদকীয়াজনক গ্ৰেপ্তাৰ কৰাৰ বাবে ঘৰ তালাচী কৰি পদকীয়াজনক ঘৰ তালাচী কৰা হয় যদিও পদকীয়াজনে পলাতক অৱস্থাত থাকে যদিও পৰৱৰ্তী তদন্তকালত পদকীয়াজনক এই মুঙৰ ঘটনাৰ গ্ৰেপ্তাৰ কৰি মাননীয় আদালতত ন্যায়িক জিম্মালৈ প্ৰেৰণ কৰা হয় আৰু গোচৰটো আণ্ডাৰ সেকশন 323 354 341 294 306 IPC read with section 8 of POCSO Act ৰুজু হৈছিল যদিও তদন্তকালীন সাক্ষী বাদী জবানবন্দীৰ পৰা আৰু ভিক্টিমজনীয়ে মাননীয় আদালতত দিয়া 164 ষ্টেটমেণ্টৰ মতে জবানবন্দী চাই উক্ত পদকীয়াজনৰ বিৰুদ্ধে 341 294 354 506 376 IPC read with section 8 of POCSO Act অপৰাধত সত্যতাৰ প্ৰমাণ পোৱাটো সুপ্ৰতিষ্ঠিত হোৱাত আইনৰ উক্ত ধাৰাত পদকীয়াজনক বিচাৰৰ সন্মুখীন কৰিবৰ বাবে অভিযোগ পত্ৰ মাননীয় আদালতত দাখিল কৰা হ'ল this is the as per lordship the submit section 8 of the POCSO Act now my lord then after my lord this honorable trial court my lord the framing of charge my lord section 23 my lord page 23 my lord page 23 it's charge order my lord page 23 may I read The accused Rahul Tumung is produced from jail hazard. I have heard the both sides charge gone through the case record carefully. Upon consideration of the materials on record, the documents submitted there which the after hearing the submission of the learned counsel both said I am the opinion that the ground presuming that the accused committed an offense punishable under section 341 376 as well as 6 of the POCSO Act. Then after my lord the honorable trial court the charge submit charge framing my lord offense under section 6 of the POCSO Act. Now, my lord, already, my lord, page 25. This is the informant statement recorded, my lord. Page 25, my lord. Page 25, my lord, this informant statement recorded, my lord. And now, my lord, victim statement recorded, my lord. Page, my lord. Page 28.
Both informant and victim statement recorded, my lord.
Live streaming to avoid it. Live streaming to avoid it.
So he was the owner of the plot of land covered by that number so and so, so and so, so and so. In the village Ramdia under Moza, Posim, Council, Haji Revenue Circle in the district of Kamrup. My father during his lifetime had executed a general power of attorney. By deed number 18 dated 5/6/17 of the aforesaid land in favor of one Taufikur Rahman, the son of so and so, Kamrup, as he had approached my father with the assurance that he would dispose the land for a suitable consideration. I got amount, but once the general power of attorney was executed, the said Taufikur Rahman came up with various excuses for not getting the sale alone. Recently, after the death of my father, when I went through the formalities of the said land, to my shock and surprise, I found the name of Zubeda Begum mutated in dark number so and so, so and so, so and so of the said land against the name of my late father, and came to know that 5 sale deeds were illegally executed by the said Taufikur Rahman on 23/4/2024, 26/4/24 respectively, 3 months after the death of my father, on the strength of the general power of attorney, which has automatically been revoked and had become ineffective from the day of his death. And any transfer on the strength of it is illegal. That said Taufikur Rahman kept his dark and had tried to cheat us from our rightful inheritance. I pray before you to take appropriate action as per law and bring the accused to justice, my lord. My lord, the FIR, it starts from that execution of the power of attorney, my lord. The first part of the transaction is concealed here in this FIR. May I take your lordship to Annexure B, page 18, my lord. For a certain land, my lord, there was a agreement for sale, and that agreement for sale it is a registered document. It was executed between the informant father and the petitioner number 1, Taufikur Rahman. And here, my lord, the total consideration that was 1,25,000. Total consideration that was fixed. And in this page 21, your lordship will find serial number 2. In the column of witness, Monisha Kaisop, she was the witness there in the transaction, my lord.
So you want to say there was no power of attorney, rather there was agreement for sale?
Yes, my lord. First, initially there was an agreement. So there, the informant was the witness. She has conceived that part in the FIR. Pursuant to that agreement, your lordship will find page 22 that rupees 40,000 that was paid. Thereafter, my lord, this is to RTGS. The total amount 1,50,000. That is at page 24. That was paid. So more than the amount, more than the total consideration was paid to the informant's father. So thereafter, what happened? The informant father, he executed a power of attorney with the petitioner. And this is a registered document. There is no any import there. There is a registered document. It is evident at page 30. And
after the sale of agreement for sale, for what reason he again registered in power of attorney, general power of attorney in favor of the petitioner?
Petitioner's father lives here in Guwahati, and that land is at Ramdia. Because he has taken the excess money, so he has given the power of attorney to the prospective purchaser, that was Taufikur Rahman.
Without even execution of the sale.
The first power of attorney was given.
Sale agreement was there.
Yes.
And
that was the
thereafter,
agreement for sale of land.
Agreement for sale, and as you have submitted that as per the in person to the that sale agreement,
Then
he had already paid the money.
Yes,
through RTGS or whatever.
Yes, yes.
And subsequently, why the general power of attorney was there? For what reason?
Actually, what happened due to the ill health of informant's father, he has given the power. Your lordship will find.
Power to whom? This petitioner number 1.
Power to petitioner number 1. That is because the agreement of for sale was between them. So he has given, because he has taken the money. So he gave him the power by executing this power of attorney at page 32. Your lordship
to sell the land.
Yes, so everything is there. Your lordship will find at least 32.
Okay. Yes, that's.
Lordship here,
Six, sign and execute all other
statement of-
deeds.
Lordship statement of accused, typical Roman is there, but Lordship, statement of petition number 2, Javeda Begum is not available in the case diary, Lordship. And Lordship, police says 4 numbers of documents, and as per the statement of the accused, the documents are original. Documents are original, Lordship.
Okay.
One I noticed there, Lordship. But statement of Javeda Begum is not available.
Why? Javeda is not available.
Entry of 16 to 25.
Actually, what happened, maybe his statement was recorded, but as per instruction.
Notice that today I visited the residence after getting interim. I visited
Yes.
the residence of 8th person, Tofikur Rahman, located in so and so. He, along with his wife, Javeda Begum, co-accused, was found present in their house. This notice there, and statement of
Probably
Tofikur Islam is there.
his-
But her statement is not available in the case.
But as per note, she was there. She was present.
As per instruction, my lord, his statement was recorded. And he was.
Otherwise, her involvement, what is her involvement? It's not there. I mean, she, one attorney, I mean, said it was executed in the name of Juveda.
Yes.
Why, as per you, why her statement is not available?
He has, as per his instruction, police seized these original documents of
These
power of
4
attorney and
documents
all.
from their
And
house.
they recorded his statement, my lord.
No, her statement?
Her statement, she was present, but her statement was probably not recorded, but lordship, she will go and get her statement recorded, my lord. That may be reflected.
Heard Mr. D. Bora, the learned counsel for the petition, and also heard MS Anders, the learned additional people, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Bora that in person to interim order dated 29/01/2025, both the petitions appeared before the IO and cooperated in the investigation of this case. All the original documents were already produced before the IO and those were seized by police in connection with this case. Full stop. Both the petitions are also ready and willing to extend their cooperation in further investigation of this case if they are granted with the privilege of pre-arrest bail. Next para. MS does the learned additional PP submitted in this regard that from the note of the IO and from the materials available in the case diary, it is seen that both the petitions appeared before the IO. However, the statement of the petitioner number 2 is not available in the case diary. But note of the IO speaks that both the petitioners were appeared before the IO after obtaining the order of interim pre-arrest bail. Further, she submitted that case is sufficiently progressed as the original documents were already seized by police in connection with this case. Next para. Considering the submission made by learned counsel for both sides and the materials in the case diary, the conduct of the accused petitioners, I find that pastoral interrogation of the present petitioners may not be required for the interest of the investigation. However, the petitioner number 1 is hereby directed to appear before the IO within 10 days from the date of order and to record her statement.
Petitioner number 2, my lord.
Sorry, petitioner number 2, to record her statement under section 183 BNSS. Full stop. Considering the entire materials in the record as of the case diary, both the interim order granted dated 29/01/2025 is hereby made absolute with the same terms and conditions. Okay.
Much so.
29.
May I please, Your Honor?
Yes.
This application is for under section 482, my lord. Case is charge sheeted, my lord. Evidence has not started. I have no knowledge about the case. I have been charge sheeted, my lord, showing me absconder, my lord. My lord, regarding the absconder charge sheet, your lordship has came across several cases of our own high court, my lord. And your lordship has also given a due emphasis and they considered the case also. And my lord, thereafter, my lord, I would like to place several judgment before your lordship of our own high court as well as Supreme Court that after 438 of charge sheet also 438 lies. And earlier I argued the matter, they are different court wants judgment. I said I will place the judgment. That's why I'm ready, madam. This I think when a scan copy has also come, madam. So, my lord, first I would like to rely upon the judgment, my lord, Honorable Supreme Court, my lord. That is the your lordship will find that after charge sheet also bail was considered, direction was given, my lord. Kindly, I have underlined, my lord. Regarding, my lord, our own high court judgment, two judgment I am placing, my lord. That court cannot, following the provision of CRBC, without following, cannot submit this charge sheet showing absconder, my lord. Then, my lord, I am placing another judgment where 3 times High Court has rejected 430. Supreme Court has granted the bail after charge sheet. This is the latest judgment of the Supreme Court, my lord. Then, my lord, the famous case Bharat Chaudhary, your lordship has came across this case many times, Bihar, where also 438 has been considered of charge sheet. Then, my lord, 2024 case of Supreme Court, my lord, Musher Alam, there also said after charge sheet bail can be considered. This is the latest judgment, but Musher Alam. Then, my lord, I am placing our judgment of our own high court. Azmul Hossain Lashkar, my lord, it has been, my lord Justice Shoikia has granted. Then, my lord, who is the Baki? Then, my Deepak Nizar, POSCO case, my lord has granted 438, my lord. Then Azmul Hossain Lashkar also granted by my lord Justice Shoikia. Then, my lord, Riazuddin Justice Count, my lord, has been considered. These are the submissions. I pray that I want to appear, my lord. Kindly protect me for a few days. I'll pray for regular bail and rest is with my luck. In the regular court, I'll go, I'll appear, my lord. And meanwhile, my lord,
So we have to annex the order sheets are there?
Yes.
In the scan copy?
Scan copies order, but their charge is not framed yet, lordship.
Charge is not yet framed.
801.1 kg ganja was recovered.
Yes, ganja to record. There are other accused also, my lord.
He is the owner of that shop. Several attempts were made to connect him, but he while this switch off and he's still absconding from the investigation.
But wait, section.
Attempt was there. Attempts were there.
Attempts were there.
And he.
After such, he was not in the house.
So what is the position? You're against him, and he now still the summons are there or NBW?
No. Bailable warrant has come.
Initially, someone was there.
Yeah, earlier someone was not served. Bailable warrant has been sent. It has been not served, but I have collected it from the court.
He is not cooperating with the investigation.
Yes, excuse me. Investigation is over. Now I have to face the trial. I will go to a gallows or I will get acquittal. That is true. Now I am interested to when I come. The only thing lawman is involved, my lord. We must respect the decision of our own high court that there are so many things you should find. Police always passing the order of this absconder. But you must respect the laws. Provision of CRBC 82, 83 has to be followed before passing such orders. That has not been done.
Now, see, that's why that is the question. Question is that the police has no authority or power to charge it a case showing him as an absconder. That is the law.
Yes, that's true.
That is the law. But the question is that the court below or the special judges or whoever there, they are issuing simply summon, not the warrant
Warrant.
on the
That I
strength
have
of
submitted, what?
this one.
Yes.
That is why we are the court that the police has no authority, but
Yes.
that and when the court of the or the view of the honorable apex court or high courts, several high courts, the trial judges are issuing not the warrant but the summon. But
Yes.
obviously.
But that's why Bharat Chaudhary's case, in other case, Bharat Chaudhary find that there is apprehension of him. If he appear, he will be sent behind the bar.
Now what to do? Now regarding if as Mr. Goswami has submitted that your entire material was, the contraband was recovered from your shop, and then you are not aware of, is quite a thing to consider at this stage. Yes, and that too, as per the CD or the case diary, several attempts were also made to arrest you, and then your mobile was also found in a switch off condition. So, but yes, obviously we'll give you some protection.
Yes.
Try to appear.
And your lordship, in the other day, your lordship was given a consent every 15 days I have to appear to the court. I am appearing in Silchar court case. Any condition, my lord. My lord, we are collecting this judgment, my lord, to please your lordship, my lord. Rest your decision by your lordship, my lord. We have no other. We have seen what my friend said, submitted is absolutely correct. But we are going after one of the judgment where is there the loophole, so you can at least place something before the honorable, my lord, at least. That is my submission.
I heard Mr. S.C. Biswas, the learned counsel for the petition, and also heard Mr. D.V. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application under section so-and-so in connection with so-and-so. Scanned copy of the case record has already been received. Bears the same. So now you are shown absconder on what ground you are specifically taken, you are not aware of.
I am not aware of.
And you have not
I was
searched
not
by
informed,
police
but
during
police never
investigation.
came to my house.
Never came. It is submitted by Mr. Biswas that the present petitioner is innocent and he is no way connected in the alleged offense. And he was not aware about the pendency of the case against him, as the police never searched for him during the investigation of this case. However, coming to know about the issuance of BWA, bailable warrant against the present petitioner, he appeared before this court with a petition for seeking some interim protection so that he can appear before a learned trial court below and can contest the case accordingly. Mr. Biswas further submitted that the anticipatory bail also can be granted even a person even in a case of charge seated one, and in that to substantiate the plea, he relied on some decisions of the coordinate. This is orders passed by the coordinate bench as well as by different high courts. Select someone and we'll give you. We will paste this as poster. Next para. First, Mr. Biswas further submitted that the present petitioner is a permanent resident of his address locality and he will appear before the learned special judge on each and every date to be fixed by the court. Poster. Next para, Mr. Goswami, the learned additional PP submitted in this regard that the 801.1 kg. 801.1 kg of ganja. Ganja was recovered from the shop house of the present accused petitioner, and during investigation he never cooperated with the investigating officer. Full stop. Several attempts were made to apprehend the present petitioner, but his mobile he was found absconding, and even his mobile phone was in switch off condition. Accordingly, Mr. Goswami raised objection and submitted that it is not at all a fit case to provide any interim protection to the present petitioner. Next part. Hearing this submission made by learned counsel for both sides and considering all aspects of the case, the petitioner is hereby asked to appear before the learned trial court will learn a special judge within 15 days from the date of order. And till then, no corrosive action shall be taken against the present petition. He will appear before the learned special judge with an regular application for bail, which may be considered in accordance with law. With the above observation, so he will be protected for 15 days, appear before the act.
Developed.
কেইটামান দিব গুৱাহাটী হাইকোৰ্টৰ কেইটামান দিব বেলেগ হাইকোৰ্টে এটা বা দুটা দিব
30.
Application. Is an undisputed bill application, my lord.
Yes.
That case registered under section 22B and 29 of the NDPS Act. The FIR case 12.
It's a commercial quantity case.
No, my
or
lord, it is intermediate.
intermediate one.
My lord. My submission before lordship, my lord. The my lord contraband articles were my lord seized from the house of one Rafiul Islam. He is my elder brother.
Elder brother.
Elder brother. We are
Not
my lord-
from your house.
No, my lord. And my lord, he was not my lord there on the date of my lord occurrence. He lived at my lord Golpara at my lord 6:30.
He was not available.
He was not available. And my lord, third my lord submission before lordship, my lord, the tapentadol tablets is not a my lord psychiatric substance or nor a my lord narcotic drugs, and it is not my lord within the schedule.
Tramadol tablets.
Yes, sir. Tapentadol tablets.
No, but there is some percentage, I think. Tramadol as a whole, I won't say, but there are some percentage of it for that reason.
Since my lord, it is not within the schedule. But
No,
this
no,
is-
it's there only. Tramadol contains if some psychotropic substance, the tablet itself, then it may come under NDPS. I don't know what is the FSL report and all, but
On the last date, my lord, I have submitted a judgment of the Jammu and Kashmir High Court, my lord. It is my lord, clearly stated that my tapentadol tablets is not my lord within the psychiatric substance.
don't know. Yes.
Although if it is not a contraband, my lord, why did he keep my lord 1400 numbers of capsules, my lord, tablets, my lord? Assuming it is not a my lord, illegal drug, my lord. Why he has kept, my lord? This 1400, my lord, tablets, my lord.
Tablets. Why, for what purpose you have
What
taken?
purpose, my lord?
What purpose?
No, my lord, it is not it was my lord seized from the house of my elder brother. My lord. It is not under my possession.
Your elder brother got arrested here?
Yes, yes, arrested and he was released after my lord 54 days. I have next year with the money water. Yes, 21 my lord, he was arrested and subsequently he was my lord released after 54 days.
Okay. Yes.
To page number 12, my lord, FIR.
Yes.
FIR, my lord, second paragraph, middle portion. During the search in the house of Rafiqul Islam, the below noted items articles have been recovered from inside his room, which was kept concealed beneath his bed. But another person, namely Saidul Islam, had managed to flee away from the post of PO. The below noted articles have been seized by me from the house of Rafiqul Islam as per Sijar my lord. My lord, his brother was also present, my lord. He fled away, my lord. Now, my lord, his brother is, my lord, that is the present petitioner, my lord. He is also involved in the, my lord, NDPS case, my lord. And he was earlier arrested in connection with the, my lord, NDPS case.
Earlier.
Earlier, my lord. That is reflected from the case then. And my lord, in the statement of the accused, also arrested accused, my lord, Rafiqul Islam also, my lord. He has implicated his brother, my lord. So, my lord, it is not a fit case to, my lord, to grant the privileges of 3 years bail.
And your FSL is not yet.
FSL is yet to collect, my lord. Investigation is pending, my lord. And cash amount of 60,000 rupees also recovered, my lord, along with the contraband.
Your tablet name is Tapentadol. It is Tramadol.
Definitely.
No, it is temedal or what? It is written as tapentadal. Tapentadal is a tremoral tablets. We are not sure about it. I'm also not conversant with
That was
that.
revealed from the mother to
FSL only. Yes. Heard Mr. D. A. Kayum, the learned counsel for the petition, and also heard Mr. R. J. Borwa, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD received, whereas the Next, right, it is submitted by Mr. Kayum, the learned counsel for the petitioner, that he is innocent and he is no way connected in the arrest offense. On the particular day of incident when the Alice contraband was recovered from the house of his elder brother, he was in Valpara and later on came to know about the recovery.
He was came to Guwahati from Golpa.
Yes, from after coming from Golpara.
Yes.
Further, he submitted that the tramadol tablets also does not come under the purview of NDPS and NDPS. However, as the recovery was made from the house of his elder brother, he has the apprehension of being arrested in connection with this case, and accordingly, the present petition is filed seeking anticipatory bail. However, he is ready and willing to extend his cooperation in the further investigation of this case if his anticipatory bail prayer is accepted. Next one, Mr. Borwa, the learned additional PP, submitted in this regard that 1400 numbers of tapentadal, tapentadal, tapentadal tablets were recovered from the house of the present petitioner.
No, from Rafiqul Islam.
But it is same house.
But I am living separately. I have the clear statement. I'm living separately.
But he will go by the FIR only, na? His submission I'm recording.
Yes, he submitted that.
He will go by the submission from the house and from the position of his elder brother. And during investigation, it has come to the knowledge of the investigating officer that the present petitioner is fully involved in the alleged offense along with his brother. More so, his brother also implicated the present petitioner, showing his involvement. Mr. Borwa further submitted that from the materials available in the case diary, it also reveals that the present petitioner is also involved in similar kind of offense, and earlier also he got arrested in the case of NDPS. Mr. Borwa further submitted that it is not he is not in a position to say about the contraband, the nature of contraband which was recovered, as the FSL report is yet to be collected by the IO. Mr. Borwa accordingly raised objection and submitted that it is not at all a fit case to allow the accused to go on to grant the privilege of pre-arrest bail to the present petition. Next paragraph, considering the entire submission made by learned counsel for both sides, materials in the case diary, and the gravity of the offense, vis-a-vis the previous conduct of the accused petitioner, I do not find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner, and the same stands rejected. Your petition stands.
Please, your lordship. Yes. My lord, in this case, my lord, step has been taken, my lord, to the respondent number 2.
Respondent number 2.
Service report is awaited.
Service report awaited, my lord.
Okay, then you take instruction regarding the service on the next date. If service is there, then we'll appoint an amicus. You know, heard Mr. M. Islam, the learned counsel for the petitioner. Also heard Mr. R.J. Borwa, so and so. From the office note dated 22/04/2024, it is seen that the service is still awaited for the respondent number 2. Accordingly, Mr. Borwa, the learned petition PP is hereby asked to take instructions regarding the service of notice on respondent number 2. List the matter accordingly. Yes, Borwa, when it can be listed, you just take instruction on that day we may appoint an amicus if service is completed.
Fifth month.
Pardon?
5th of May.
Yes, okay, 50. 5. Listing it on 5 on day will appoint an amicus.
Highly obliged, Your Lordship.
32.
Lordship, 32 and 33 same city, Lordship.
32 and 33. You are appearing both in 32 and 33?
Yes.
In Lordship, in
In
32,
32, you are on interim.
Yes, in
both Lordship.
In both the matters, you are on
Yes,
interim.
Lordship. In 32, petitioner appears statement recorded. And in 33, petition number 1 and 2 appears statement recorded, but 3 and 4, their statements are not available.
33 record to do this. And interim in both the matters were granted on same day. Or 1 day prior. 1 day only prior.
12, 3,
Your
25.
CD is available, updated till when?
Date of entry is
Last
7/4/2024.
after detail. So do you have any explanation why 3 and 4 did not appear?
Lordship, in this case, Your Lordship, 1, 2, 3 for all the partners and the family business, Lordship. And
No,
1 and
whatever. Why
2
3 and 4 were not appear?
1 and 2, actually, in the business, 1 and 2 are actively, Lordship.
That is not the point.
They have appeared before the police.
You are active, they are inactive.
Yes,
They are not on
police
that.
are informed, Lordship, that they are statement while they have appeared before the police, Lordship. Police also informed them, Lordship, their statement is not required because they are not actively involved in the business.
Not
Lordship.
required. Is there any note from the IU?
No, Lordship.
While they appeared before the police station, Lordship, before the IU. And,
It is surprising. Police cannot say because they were on interim. So it's a duty of the police to record their statement.
they are the father and mother, Lordship. They are not-
Father and mother. Whose father?
Police recorded statement of the alleged
Yeah, but
accused
some-
Bhagavati, Rachit Pratap Sharaf, Rohit Pratap Sharaf. As per the honorable, but no other note. Lordship.
Petition number 3 and 4, father and mother of petition number 1 and 2, Lordship. The family
Okay, then we'll make a direction there. Their records should be there. Their involvement may not be there as they have submitted. May not be there because they are father and some sort of, I don't know, there may be or may not be also. Pradeep Saraf.
Let them appear. 3 and 4.
And AB is for only 1. No, sorry, 32 is?
33.
No, 32.
32 appeared, Lord.
32 appeared, Lordship, and
32 appeared.
32 appeared. In 33, 1 and 2 appeared.
Then both the matters you want to list it together or what? Let it be on together, I think.
separately, Lordship, first matter may be heard.
First matter may be heard. Yes, what do you want to say? Submit. Yes, 32. Out of same FIR, these are? Out of same FIR? Yes.
Also, this FIR was registered under the Copyright Registration Act, Lordship, and another section of BNS, Lordship, 318. FIR is a page, Lordship, 13. With a long FIR, Lordship, filed in the
You can tell us just gist of the
Lordship.
What is the gist of the case?
Yes, so the informant is the Lordship, is a large scale manufacturer of Lordship plywood. It is Century Plywood Private Limited, Lordship. And they produce plywoods in the brand name, Lordship, Century Plywoods, and they have registered under brand name Century Club Prime. And another is, Lordship, their artistic work for GLP. And they come to page number 14, Lordship. In the FIR, 2 paragraphs is important, Lordship.
page 14, second paragraph. May I read, Lordship? We state that the supplier is distributing, supplying for the purpose of trade, infringing copies of renowned GLB copyright in the artistic work, thereby affecting the exclusive right of the complainant with the meaning of Section 51, Section 63/65 of the Copyright Act, 1957, the copy of the copyright is enclosed.
Your brand, otherwise your brand name is?
Our is Canon Club Pride. Canon. Brand name is Canon, but we are using Canon Club Pride. But thing is that in this case, their allegation is a violation of GLP. The word GLP. We are also using GLP. They are also using GLP. The word, and they have registered under the Copyright Registration Act in a specific artistic work GLP. In this regard, we have filed one additional affidavit also, some records. That is page number 43, running page 43 of our additional affidavit. We have annexed our photograph of the plywood, Lordship. We have used GLP, the below. The word GLP.
GLP.
Page number 45, this is the informant plywood. We have annexed the photograph. Here in the third column, second row, GLP. Their artistic work is like that, GLP.
GLP.
And one certificate we have got from online, Lordship, that is page number 44. Their GLP work, that is, Lordship, registered under the Copyright Act as GLP. It is the design. And not only our company is using this GLP word, the other brand also using the GLP. This GLP is the technology for which they are using GLP.
Oh, watch it.
So from page number 46, we have another brands. So all the brands are using the technology GLP. They are using glue line protection.
Oh, watch it.
So different brands are using GLP. They are specific artistic work is GLP that is mentioned in their certificate. I have annexed this at page number 44. But we are using GLP is something different. It is not exactly similar with their artistic work GLP. And another brand also using this, but they have filed this FIR just to harass and nothing else.
Okay, otherwise his cooperation is there.
Cooperating laws.
That's reportable. Reportable. You are Mr. Enat, counsel for the petition. Also heard Mr. MS and the still an additional PP appearing on behalf of said respondent. This is an application under section so and so in connection with so and so. Case diary received, where is the same. It is submitted by Mr. Nat that after obtaining the interim order of rearrest bail dated 12/3/2025, he already appeared before the IO and cooperated in the investigation of this case. He is further ready and willing to cooperate in the investigation of this case if his interim bail is made absolute. Next, MS DAS also submitted in this regard that the petitioner had already appeared before the IO and his statement is also recorded on section 183 BNSS and extending his cooperation in the investigation of this case. Considering for access to your 12/3/25 is we are made absolute with the same terms and conditions. And 33 regarding the 33.
Regarding 33, just one submission I want to make. Also, actually, they are not the producer of the plywood. They are
now see, we are not on that. The question is that the court directed court allowed them with some interim protection with a direction to appear. That direction you cannot violate. That is the you may be involved, may not involved. Okay. Mr. Enat so and so koribo or ligman cases likhon lage. It is CD received koribo. It is submitted by MS and DAS that the that the statement of the petitioner number 3 and 4 are not available in the case diary. Case diary, though the petitioner number 1 and 2 already appeared and their statements are recorded. In that context, the petitioner number 3 and 4 is hereby directed to appear before the IO and to record their statement under section 183 PNSS within 7 days from the date of order. In next date of listing, the interim order for all the petitioners are extended. List accordingly when it can be listed.
On 15th of May.
Also, that also the thing is that the marriage ceremony of petition number 1 will be held in Rajasthan Lordship. So I have to ascertain the date. They are the father and mother's Lordship. So kindly accommodate the date Lordship and after some time.
Till when you want to?
Within 5 minutes.
Within 5 minutes. No, within your marriage is on fixed on when?
Just confirm Lordship. I have my
okay.
After
Yes.
5 minutes.
Okay, just confirm it. Okay.
CD to be written.
CD not to be written. I think if he wants a longer date, otherwise also CD has to be there because the statement will be there. Okay.
CD to be written.
Okay, you just intimate us.
35.
Yes. Case diary was called for Lordship. FIR Lordship will find out is well Lordship.
So you were on interim, I think?
Yes, Lord.
So what is your submission? Have you appeared before the
Yes,
IO?
Lord. Yes, Lord.
His appearance statement recorded.
Yes, Lord.
How many petitions? 1. 6 petitions.
6 petitions. That is that Lordship. In the day of occurrence, that is on 13/1/25, the petitioners lodged an FIR against the complainant, Lordship. And having come to know about lodging of that FIR, they lost this instant FIR on the next day, that is 14/1.
But your petitioner, your FIR is registered earlier?
No,
Earlier
Lordship.
today?
No, Lordship. That
Your petition,
yes. Our the petitioner's FIR was registered earlier, Lordship. Yes, Lordship.
And regarding the injury Lordship, there is injury as there also. Grievous.
grievous injuries day?
Yes.
For the victim?
For a victim. 2 persons were injured Lordship. Both are grievous in plant and witness also instigated this petition of them. Otherwise, they have appeared and statement is recorded.
Now
Regarding land dispute, Lordship, there.
Boundary, regarding boundary, Lordship.
Confrontation took place and witnesses were indicated. Akas Ali, Asraful Islam, Arshad Ali, Azhar Ali, yeah, all the petitioners.
all the petition. URMS BDB?
BDB.
RMS BDB, the learned counsel for the petition. And also heard Mr. DP Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application on section so and so in connection with so and so, CD receipt, verification. It is submitted by MSDB that the present accused petitioners have already appeared before the IO and cooperated in the investigation of this case. She further submitted that the present FIR has been lodged with some false and concocted allegation only as a counterblast of the FIR lodged by the accused side, petitioner side. However, the petitioners are ready and willing to cooperate the IO in further investigation of this case if they are granted with the privilege of pre-arrest. Next one. Mr. Goswami, the learned addition PP submitted in this regard. There are that most of the witnesses had implicated the present petitioners and showing their involvement, alleging their involvement in the said offense. He further submitted that the incident had occurred due to land dispute between two groups. Further, he submitted that the injury report of the victim shows the grievous injuries on their person. However, he submitted that all the petitioners have already appeared before the IO and cooperated in the investigation of this case. Considering legal play, absolute. Okay, your bail is not absolute.
Petitioner is on interim. We have not received the case diary.
Case diary
I have
not
an interim
received.
lordship.
Case diary
Case diary
not
not received.
CD not received, issue reminder. Yes, when it can be listed?
16/5.
16/5. List on 16/5. Interim be extended till next date of list. Much obliged.
38.
Okay, yes, you are appearing as a CBI?
For
standing
CBI, as a retainer counsel of the CBI, recently appointed.
Okay.
Pursuant to the interim order, Lordship, the petitioner appeared before the investigating authority. Because Lordship was pleased to grant the interim protection, and pursuant to that, he has already appeared before the investigation.
On the last occasion, most probably Mr. Chaudhary was submitted that their appearance regarding RKD Chaudhary was there. So anyway, interim bail was granted to the petitioners.
It has been granted to, already granted.
No, interim. Have you granted?
Earlier it was granted interim.
Earlier in a sense, in the last occasion that
CD,
is
I have brought the CD. CD is there.
No, definitely, we call for the CD. Now we are going to hear you, adversary, but as per him, he already, most probably the petitioners already appeared, and that was the condition of the last occasion also. 27/3/2025, we passed the order.
Since I have the information that 35 notice has been sent to him on twice, and he has failed to appear in the CD. It is, once it was sent on 11/2/2025 and 31/2025. Two 35 notices.
Just a second. You also see the case diary. Our interim order was passed on 27/3/2025. Thereafter, whether he appeared or not appeared.
That I will
His
have
statement you have to go today.
take instruction. IO is outside. Can I
No,
take
take instruction is okay, but your there it is not there regarding your statements.
for 2025?
20?
22 last order.
Last, yeah.
22/4/2023. Further open.
22/4.
Yes, yes.
That means in the month of April. But the interim was granted on 27/3, but up to 22/4, you don't have any record in the regards to their appearance before the IO. Then what is
I
there?
have appeared, Lordship. I can place it on oath, Lordship.
No.
Specifically mentioning the
let me
date,
have the
Lordship.
instruction. Maybe he might have appeared there.
Then it may be available in the case diary, Lordship.
Yes, it should be available in the case diary if he appeared.
Contacted say Yaswant Kumar, senior manager, so and so. And he informed over phone that the Kudra Sanchelo. This is the last order 22/4/2000. If I may be permitted 1 minute, I can. He's outside.
Now see, taking instructions from your IO is otherwise, but the question is that his statement or their statement has to be there available in the case diary. That's what. Or do one thing, if you need some time to peruse the case diary and all, we may fix a date so that you can peruse the case record and see as to whether there is any whether.
He has come.
Yes, you can.
तो चाको तो इसमें ये जो आपने दिया है 35 का अपीयर नहीं किया है हाँ उसके बाद अपीयर किया है। Okay. On getting the order, he appeared. पर इसमें नहीं है last order. इसमें नहीं लिखा है. 22 कहीं 22 का अभी बोल रहा हूँ. On getting the order, he appeared.
No, last occasion he submitted that he received the 35, but as there is some apprehension of so and so, so he prayed for it so that he can appear. Accordingly, we granted, and he most probably appeared as you have submitted. So if you need some time to go through the case diary, that's what I'm saying. You can pray. Otherwise, you have, if you want to place something, we are ready to hear.
Sir, then kindly give some time.
Some time?
Let me go through the case diary. Also today only I received that.
Okay,
Only
okay.
after
No, I
the
have seen this case diary is also a voluminous one,
Yes,
so
voluminous. Only
it
today
may
the
take
code,
some
yeah.
time. That's what I am asking.
Yes.
Maybe on Friday.
Friday, I cannot say. So, matter Friday is key time.
Second of them.
Second, actually, what had happened, there are some issues popped up regarding the, that's what you also know. We also know that ground of arrest regarding. So, we are hearing around 9-10 matters, most probably on second. So, may not be possible also. That's what I'm saying. Maybe on, as you are interim, we are extending your interim. By that time, CD will be written and she may peruse the case diary.
Reason is there in paragraph number 5. They have already admitted earlier their anticipatory bail has been rejected. So they will have to only cooperate with the IO. That's all. So there is no question of giving them an anticipatory bail. Earlier it was rejected and it is admitted position in paragraph number 5 of this application.
But let
Their
me clarify
application.
one thing. I have annexed the order also in connection into paragraph number 5. It was closed on basing on their submission. They submitted that it is it is available in page 37, Lordship. If I may read, Lordship. Mr. Halloi has submitted that the search sheet has been laid in connection with so and so. There is so and so, but the name of the petitioner has not been reflected in the search sheet as accused, and the matter may be dropped. It was their submission.
As of now, this is the same position. Their name is not reflected in the charge sheet. However, further investigation is going on. That is why he has been called.
Then
For
on basing
certain
on this submission, Lordship, the interim may be made absolute, Lordship.
How it can be made absolute? No,
Now,
So
see,
he
there are two, three
it
things.
is
Question is that
accepted
earlier bail
He
application
has
or the,
risen.
no,
He
no,
has to
earlier
cooperate.
as, no,
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 I
as
am
Mr.
cooperating,
Das
but-
has submitted that earlier, his earlier anticipated bail was rejected. Only considering the submission of Mr. Halu that their name is not there and thing is there. So it was accordingly dropped and the anticipatory bail was, it was found at that time that anticipatory bail, there is no apprehension of arrest. But subsequently, when the investigation is going on, then he received because investigation is open. So that after that only he received most probably 2-3 notices or whatever. On that basis, he approached this court seeking anticipatory, and that regard we just granted him interim. So now his cooperation, you will be the best person to see the case diary, to peruse the case diary and to tell us. That's what I'm saying. So we are extending his interim till next date of listing, and you retain the case diary, go through it and submit the submission. When can it be? Will it be convenient for you on 16th?
16th of May.
This May,
I
16th
will
of
be
May.
there on 16th.
You will not be
15th,
there till when
Either
you are
way.
here.
It may be 10 or after 16.
It may be 10 or after 16th. Up to 10 is most probably lots of matters are there. 10 padi in
Maybe after 16.
Saturday. 10 and 11 are this holidays in fact.
After
10,
16.
11 and 12 in fact. Then after 16th it will come in for you.
After 16, then it would be 19. 19 is Monday.
19.
Yeah, 16 is Friday, 17 is Saturday. So 19 would be Monday.
But after 19, will you be able to retain the case diary?
I will ask them to bring again.
Will you return back? Return it back or what? No, we have to pass the order. No, that's
Yeah, he will take it back and he will bring it.
no. In record, we have to mention here. We will mention the retaining order or return back order.
If your lordship want to retain it in the court, then it is okay.
No, I am not retaining here. It is
Then
up
I
to
will
your
return
duty.
it back.
Return back? Okay, return back the case diary. Return back the case diary.
With the instruction on the next day, he will bring.
Okay. 19.5 we are listing.
Interim
19.5.
effects.
Interim be extended till next date of listing. Okay, we are listing.
Okay.
And B 33.
Also, their marriage ceremony is also 5 and 6 of May.
I know her. That's a detail. Yes, pardon?
Marriage ceremony is at Lordship 5 and 6 May, and they are returning by 28th of May, Lordship, to Guwahati. Marriage ceremony at Rajasthan, Lordship. So after 20, Lordship, on any date, Lordship.
No, after 20 we can fix the data, but there will be an direction to appear before the IO. 20 it's okay.
After 20, Lordship.
After 20 we can
after 20th of May, any date.
Their recording of submission also after 20. How many days we want to then?
Because thing is that also they are already in Rajasthan, Lordship, and the marriage ceremony is
Such kind of cooperation cannot be given. They are accused after all, what to do? We cannot give. Your date may be listed. Yes, we can list your date after 20. But direction will be 7 or 10 days. It's up to you only. You can come from Rajasthan, or if you in that way, if you violate the condition of deposit, your bail will be rejected. That much only. They are Rajasthan now. How can we incorporate all these things? They are Rajasthan. That's why I'm saying that your date may be fixed. After 20, it's okay. We are going to fix 20, 25, whatever you want. But the question is that for appearing before the IO, we cannot give you such time. From Rajasthan, there are flighters available. You can come and depose. If you want 10 days, we can also extend it to 10 days also.
10 days.
10 days, we are extending it to from the 10. Within 10 days, you appear and cooperate with the investigation. Your date, your recorded evidence be recorded, and then we fix will date. So order will be there for 10 days. And then your next date will be 2025 officer date of substance. That we can cooperate with you. It's okay. 27.5 we are listing after your marriage. Okay. But within 10 days you appear and cooperate. Otherwise, it will be considered as a violative of your condition and your bail will be rejected. Okay, we don't do any. চব কৰিব লাগিব ৰাজস্থানো যাব বিয়াও পাতিব আহিব তাৰ পৰা বুঢ়া মাকে ক'লে কি কৰিম এতিয়া service is awaited in fact.
Service awaited and there is no interim and CD might not.
We have not received the case. No, interim cannot be.
No.
CD have received, not received.
Short date may be not granted. And
short date will not suffer some purpose. We'll ask the public prosecutor to take instruction regarding the service. If it is their service, then on day itself we'll appoint an amicus. If they do not appoint any other one, or the matter will be there. In the meantime, we'll call for a case diary.
Yes, reminder in the
CD not received. Issue reminder corridor. Further, office note dated 3/4/2025 reveals that service is still awaited for the response number 2. In that regard, Mr. Goswami, the learned edition PP, have been asked to take instructions regarding the service of notice. List accordingly. So it can detail 665. Will it be possible 6.5, Mr.
From Morigaon.
Possible, no? Okay.
And reminder for CD.
Yes, yes, obviously. We are issuing reminder.
42.
Services. Well, the same is 39. Notice has not been served. Here notice served, not served. Office note
Still
21.
awaited.
Office note 21/4.
21. Same order, then we'll take instructions.
Yes, ma'am.
And it will be fixed on, say, maybe 5/5 corridor. 9/5. Okay.
Right.
Same order, no?
Okay,
40.
Okay, supply days.
47 to 9 can 8 to 47. Any call, sir? Leave it. 47, none appears on call for the petition. Further, the office note dated 25/4/2025 also reveals that scan copy from the trial court, learned court below is still awaited. Registry will do the needful. List accordingly after 1 week.
48.
Yes.
Here's bail application, madam.
Yes.
CD was, CD is not available, I think.
CD not received. Scan copy was received. Why scan copy is called for?
But we call for the case diary only.
Yes, madam.
Yes, scan copy of the case diary received.
Wrongly.
So we have to call for the origin CD also.
What nature of case, this one?
Armset is there.
Armset is there.
Armset is there.
Oh,
That's only interim is
Huh?
not there. That is only interim is not there.
oh, interim to cannot be
Yeah,
given.
earlier 3 times CD was called, my lord, but till today, my lord, CD is not available.
It's from Moran.
Moran PS.
More on PS, no?
Yes.
Heard MSS Rahman, the learned counsel for the petition. And also heard Mr. DP Goswami, when said not received. Issue reminder. How will you raise the call? Can I call for it later?
Last order CD was called.
Yes, CD was called. We are calling for the case diary only. You make a reminder to this issue reminder corridor. When it can be fixed, right? 15/5? Okay, 15/5.
Obliged, madam.
For order, item 44.
Yes.
I was filed, madam.
I was filed, yes.
Madam, for correction of the provision of section 351, madam. In place of 351, it is written 35 inadvertently. That for correction, yes, I have been filed. Now, madam, the petition for 482 petition, madam. Where petitioner or received the notice annexure to page 15, madam. And he
Just a second, I is for modification.
I for correction.
I is for correction.
Correct.
For 35,
Well, in cost title as well as page number 2 and 4, and 8, and also in the prayer portion, which is written as
One of the sections is wrong. One of the section
it should be 35.
351.
Achha,
Whereas
351.
they have typed is 35.
35.
So they file this IA.
For
So
correction.
today the IA will be allowed. Then only they can press the.
Try to allow COVID.
Also, my lord, the petition for anticipatory bail, my lord. That should be also considered, madam, because, madam, the petitioner is absolutely innocent. There is nothing. One FIR has been filed against the one ex-MLA, madam. He was also released on bail, madam. So that order is there, madam. Ex-MLA, madam.
Mr. Biswas, are you ready for hearing today?
My lord, the problem, my lord, with all respect, my lord, there is a technical problem. Now, the IA is allowed today.
Yes.
So the IA order, after only the IA is allowed, then only, my lord, this petition will come. This has come for orders. Otherwise, my lord, the direction for filing an IA, there is a judicial order, 2 orders, one by your lordship and other by Justice Pathak, my lord. Then those will become redundant if this matter is taken up today, because the order is yet to be passed, my lord. So my submission would be, today since it has come for orders, let the IA be allowed, my lord. Let it come on some other day, they can press their bail application. In the meantime, they can correct their petition by hand. Otherwise, my lord, those orders will be of no consequence.
So what to do? In AB, can we pass any order? The list.
List maybe in the motion or bail hearing.
এটা allow কৰি দিওঁ দুটা কাৰেকশ্যন আছে সৰু সৰু আৰু মেইন পিটিশ্যন AB টো টিকিব লিষ্ট মেটাৰ your AB is there na so 15/5 will do 15/5
madam
15/5
Well, there tomorrow it may be fixed, my lord. It is absolutely
Actually,
better, man, I am only received the notice, page number 15, annexure 2. And due to the afraid, I filed this petition. And FIR itself says that, my lord, one Rusul Haq, my lord, he telephoned him to demand 1 lakh rupees by monthly. There is nothing. I have no relation with him. This is the my.
after tomorrow, it may not be possible, please, no? There are other matters as well.
Round of arrest series is there.
Ground of arrest is there.
Today also, in court number, Justice Goswami has given some bails on ground of arrest. Today.
Given some?
Some
dates?
bails were allowed on ground of arrest, not communicated.
Oh, acha, okay. কেতিয়া দিব পাৰিম? 14 will be too late for you? 14th, can it be?
14, he is not in interim, he is so late, madam.
5, 6, 5, 8. 8, 5. Somehow 8, 5. We are fixing it. If we do 8, 5 for you, I had to allow for you.
Okay.
See, Susan.